Thank you for joining. We're about to start the meeting. Please silence all electronic devices during this meeting. Please stand by. We're going on air in 5, 4, 3, 2.
Okay, good morning and welcome to the October 24th Planning Board meeting. We have a pretty small agenda today, so it shouldn't be very lengthy. I'll get to you in 1 second, Mr. Attorney, but let's just start with a motion to approve the minutes from our last meeting on September 26th.
Motion to approve.
Can I get a second?
I'll second.
All in favor?
Aye.
Anyone opposed? Okay. All right, I will turn it over to our city attorney.
Thank you, Mr. Chairman, and good morning, members of the board. Today's meeting of the Planning Board has been scheduled in a hybrid format with members of the board physically present in the temporary commission chambers and staff, members of the public, and applicants appearing either in person or virtually via Zoom. In order to participate virtually in today's meeting, the public may dial 1-877-853-5257 and enter the webinar ID, which is 861-4342-6327#, or log into the Zoom app and enter the webinar ID, which again is 861-4342-6327. Anyone wishing to speak on an item must click the raise hand icon in the Zoom app or dial *9 if they're participating by phone. Next, I'd like to read the city's notice regarding lobbyist registration. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the city clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they're communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. And lastly, we do have one quasi-judicial application on the agenda, so I'd like to swear in staff and any members of the public who intend to testify. Please raise your right hands. Do you swear that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, as usual, I'm going to push the discussion items to the end. And speaking of that, Gail, thanks for forwarding Amy's email. That was really helpful. So
Mhm.
thank you for that.
Thank you.
And I believe there's a motion to continue the new application. So we'll call that first. Planning Board File 230621, 624 Collins Avenue, Isabel. Mr. Larkin, good morning.
Good morning, Mr. Chairman, board member, staff, Michael Larkin, 200 South Biscayne Boulevard. Here is on the applicant. We are redoing the kitchen equipment and the ground floor, which leads to changes on the rooftop floor plan. The hearing file is frozen, so we don't have any opportunity to submit the revised drawings. So we're asking to continue this matter to the November hearing, which I hear may not happen, but at least November.
Really?
So yeah, I wanted to bring that up. We only had one item on the November agenda.
Oh.
It's not an emergency. It's the designation of the Collins Canal Collins Canal as a historic site. I don't think that's in danger of being filled in next month. So we were, you never know. We were going to propose canceling the meeting and moving that to December because it's only one item. But given that the applicant is requesting a continuance to November, I want to leave it up to the board if you want to have the meeting or.
And you don't anticipate other items coming up for
No,
November?
there was nothing referred
Is
by the
that
city
going to be
commission.
hugely detrimental to your client?
I think it'll be okay.
Okay, so December?
Yeah, the December meeting is a little early because of the holidays, so it'll be December 19th. So it's,
Wow. Okay, I'm in
Okay.
town. It's all good.
all right.
Okay, so anyone want to, anyone in the public here to speak on this? Anyone on Zoom?
We have nobody on Zoom.
Okay, anyone on the board have any comments or can we move it? Okay, someone want to move it to December?
I'll move it.
Okay, Gail first. Oh, I'm sorry, Tanya, did you move it? Okay,
Motion,
maybe she'll second it.
okay. Motion and second, and that can be by acclamation since it's no.
Okay, all in favor?
Aye.
Anyone opposed? Okay, great.
Great, thank you.
Okay, the next item is code amendments, planning board file, planning board 230630 live local act administrator review on page 27 of the books.
All right. So this ordinance was referred by the city commission as a way to clarify some of the provisions of the Live Local Act. The Live Local Act, by way of background, was approved by the Florida legislature, Senate Bill 102 this year. The Live Local Act is intended to incentivize the development of workforce and affordable housing, and it includes several preemptions for local government zoning regulations. So as a result, this ordinance codifies exactly how we're going to interpret those provisions and how we're going to treat projects that come to the city requesting the preemptions that are provided for in the act. Just so that I'm going to go through what those preemptions are so you're familiar with them. It states that a municipality must authorize any projects seeking the benefits of the Live Local Act administratively. So we would not be able to bring those projects to the Historic Preservation Board, Planning Board, or Design Review Board. It requires that those projects, at least 40% of the units, for a period of 30 years, be limited to an income of 120% of the area median income. So that more or less falls in line with our definition of workforce housing. So 40% of the units need to be affordable for the workforce. It requires that we not restrict the density beyond our highest allowable density in the city. Our highest allowable density is 150 dwelling units per acre. Plus, we allow an 80% bonus for workforce and affordable units. So even if you're in a district that has a lower density, we cannot restrict you beyond the highest density in the city. It provides that we not restrict the height of the development greater than the highest height limit within a mile of the development. So if you have a district within the mile that allows for a higher height, you have to allow that higher height within the district. It provides that Everything else needs to comply with the local zoning ordinance. So setbacks, parking requirements, landscape requirements, other things like that do need to be complied with. It's only the height and the density that are preempted. And it requires that in cities that have less than 20% of the land area for commercial or industrial uses, that those developments be mixed use. And about 11% of the city is in an industrial or commercial district. So we are going to require that any development be mixed use. And then it also applies, this only applies to mixed use commercial and industrial districts. So for example, the RM1 districts, this does not apply. The RM2, RM3, the residential districts, single family districts, this does not apply. It's only for commercial, mixed use and industrial districts. So what this ordinance does is it tells us exactly what districts are applicable. So you'll see in the first part of the ordinance on page 35, it gives you the exact zoning districts where that are eligible pursuant to the regulations of the code. It includes the definition of what is affordable per the statute. It requires that any development, even though we're going to be approving it administratively, undergo the same process that a development would undergo today. It has to undergo site plan approval. So it would be submitted to staff, and staff would review it like we would review any project that was going before one of the land use boards. And we would issue an order with conditions similar to what we would do instead of those conditions being a draft recommendation to the board. That would be the final approved document per the requirements. It provides that any project seeking variance or waivers not be eligible for this administrative review because it would not comply with the land development regulations as required by the statute. Any project seeking warrants would not be eligible. And then in terms of conditional uses, only the conditional uses that are applicable for new construction. So for buildings over 50,000 square feet, or in the industrial district, lots over 20,000 square feet, we call those neighborhood impact structures or neighborhood impact lots, are eligible for administrative review. If you're seeking a conditional use approval for a neighborhood impact establishment, so anything with an occupancy over 299, that would not be eligible for the administrative review because it's not needed for the construction of the building. It clarifies that the density be as required by the statute, the height be as required by the statute. It also requires equivalent treatment of dwelling units. So the affordable and the workforce units can't have a separate entrance. That's something that some developers have proposed in some affordable projects in other cities where they try to totally isolate the affordable units by giving them their own not as nice lobby. They don't give them access to the amenities. So this is intended to ensure that those affordable units are treated equally. It identifies that the mixed use requirement in the statute applies to the city. It requires that all of the components of a Live Local project be on a unified site, on a unified lot. So you can't put the affordable units somewhere else and develop the nice structure on the more valuable property. It all has to be within the same lot. It identifies that everything else needs to comply. All other land development regulations need to be complied with. All other provisions of the comprehensive plan need to be complied with. And then it also clarifies that the criteria that exist today will continue to be applied by staff. So the design review certificate of appropriateness criteria will continue to be applied. The conditional use criteria will be applied. The sustainability and resiliency criteria will be applied. And any other criteria contained in the land development regulations and the comprehensive plan will continue to be applied. And then it provides the section on appeals should such a project be appealed.
Who can appeal it?
The provisions we have today. So
The appeal section, it relates to seeking review of any determination of planning director with regards to this application. So I think it generally would be the applicant. If there were a decision adverse to the applicant could.
Okay, so my understand, and I'm sorry, you guys, I have so many concerns and I'm trying very hard to be professional about this. There is no way, the way this law is currently handed down to us, that residents can appeal something going on in their neighborhood. Is that a correct understanding?
I don't think that this ordinance would limit an affected party from seeking review.
But if it's a neighborhood and it's an administratively reviewed project, that means there is no public forum to be heard. So how would residents then say, you know what? We don't want a 50-story tower overlooking my kid's school. We don't think it's a good, whatever. That's a valid concern. Where in the process, the way this god-awful law has been written, is there an opportunity for residents to stand up for what they want, what they need?
And that's a very good question. It's something we've identified as a major concern. Unfortunately, under the Live Local Act, there projects that qualify for the incentives must be approved administratively. And
So can residents come and the way they do in the halls of Washington DC, go visit? I mean, you're not our elected officials, so it's not fair to, and it's not you guys. You understand that it's not you guys, but you're now on the receiving end of this, right? You guys have the pen that says yay or nay. So if residents have a concern, the only way they could make that concern known is to come pay a visit to you or write letters or whatever. And then even so, even if it's a valid concern and under normal behavior, people would say, oh, you know what, you're right. This is something that we should adjust. The way all of us go through with all of these projects all the time, unintended consequence, we can fix the parking, we can fix the traffic exit, whatever the issue is, that's the discussion. And a lot of it is because residents say that doesn't work for us, right? It's part of the process. So this now, in addition to preempting our laws, preempts residents from making, alerting people to problems with the project. There is no recourse for that.
I guess the only recourse a resident would have is, first of all, a Live Local project application is subject to Florida Public Records Act. So if an application is submitted under the Live Local Act, the public has a right to inspect or obtain copies of that application, like they would any other. And you know, like with any other application, the public would have the ability to contact planning department staff, whether, you know, by phone or email, and you know, and make their concerns known. The real challenge is that a project that qualifies for the incentives under the Live Local Act and otherwise complies with our land development regulations must be approved administratively.
Right.
And
It's really handcuffed you all.
it has, yeah, it
And
has.
so it doesn't even come to the commission. Like it's you guys and that's it. There's no public commentary. Is there even a resident's right to know notification so that, because when things come to the commission, they have to be flagged as a resident's right to know item. And if it is going to affect somebody, a property holder within whatever it is, 300 feet, they are notified, right?
Right, right, that's right. No, because these applications will not be presented to the city commission or the land use boards.
Wow.
There is no public hearing.
So there's no public hearing, and the public hearing is the part that triggers the resident's right to know. It's not the fact that you're building a 50-story building next to my bungalow. That doesn't I'm sorry, I'm not yelling at you guys, you know that. Where's our legislature in Tallahassee? I have a few words for them. So there is no mechanism, the way this is written, the way our laws are currently written, that if you don't know, if you haven't heard that something may be coming to the lot next to you, you will not be advised of it. You will not be warned of it until the bulldozers show up. Is that a correct understanding?
So because the applications will not be presented to the boards, it would, you know, a nearby property owner would have to affirmatively request copies of the application or
Okay,
reach out to staff.
so
So
It doesn't
very
get voted on
challenging.
by the commission. There is no public appeal process or discussion process. There's no neighborhood engagement, and neighbors aren't even advised that their literal next door neighbor could go from a 1-story building to a 20-story building if it fits. Are you fucking kidding me?
Okay, I think we are supposed to opine on
Right.
the ordinance and also make recommendations. I think that would be most helpful.
I
If you have,
understand that.
no, but do you have recommendation? First of all, we have to
Right.
learn.
I was gonna say,
And-
we're not here to challenge the
No,
the
but I
law.
want to
It's-
understand.
And Mr.
because-
Chairman, I'd like to just provide a little context because
Yeah.
while the Live Local Act includes, and Rahili went through them, a number of requirements that now preempt us. The purpose of this ordinance is to create a framework
No, I
for the
understand.
city
That's what
to
I'm
to
That's-
to
that's
to review
Correct.
applications that are submitted under the Live Local Act. We're identifying district, because remember, Live Local Act has broad terms that are intended to apply throughout the
Correct.
state. We're identifying districts that would qualify, that we've determined would qualify under the Live Local Act. We've created an administrative site plan review process. We are clearly stating that the review criteria that applies to other applications like the certificate of appropriateness criteria for projects that are in historic districts, the design review criteria for projects outside of historic districts, the conditional use criteria, all of these review criteria are going to apply. Now,
Right.
staff,
You're doing your best
Right.
to minimize the
But so
impact.
the reason why I was going through this was so that we can pull out, we can recommend, we're like definitely all of this, but let's recommend some additional strengthening points. Like we can say that residents' right to know gets applied here or whatever we call it, like noted, affected parties shall be informed if there is a property adjacent to them. I mean.
Yeah, we
why-
can do that as long as it's not preempted by the law.
Yeah.
We have to
But-
we have to have the right to do that.
But we do have the right. We could, who's going to tell us that we can't even notice our residents of something that's happening in our city? I mean,
Right. No, I
mean,
don't disagree with that. Whether they have the right to do anything about it is what I'm not sure.
Well,
of,
well,
but
so,
I hear it.
but
Mis-
let's write
Yeah.
it in and let
So-
Tallahassee.
First of all, can we understand? I don't understand the ordinance that we.
Gail, if you don't mind, one
Being
second, let me
proposed,
do
okay.
one thing before we discuss it as a board. Is there, are you all done with your presentation? All right, is there anyone in here to speak on this? Okay, is there anyone on Zoom?
Yes, we have Daniel
I just
Seraldo.
want to do the public, Gail, and then we'll do the board. Okay.
Daniel Seraldo.
Yes, hi, board members, Daniel Seraldo with Miami Design Preservation League. It's very upsetting that it's come to this situation. You know, this board is supposed to be the planning board. They're supposed to be proactive in protecting us. And it was really disappointing to learn last session that this whole proposal was going through and the planning board wasn't proactive. I'm very thankful to the commission for taking this initiative. And I hope that this and the Heights will move forward. But I also think it's a warning sign. We were there years ago at Fifth and Alton saying this could be a precedent for the whole city. And, you know, it's not great to be right, but, you know, we just have to learn, I think, from our past mistakes. We're looking forward to your proactive protection of our city after several years of failed leadership in this area. Thank you very much.
Thank you, Daniel. Anyone else?
Can I ask Daniel something?
Daniel, you still there?
Daniel?
Yes, I am. Yes.
I just wanted to ask, this is Jonathan, what is it that you're proposing that we do to be proactive?
Well, I think that this is a good start. Is it a year, 2 or 3 late? Yes, absolutely. But just moving forward, we need to really look big picture, stop making these exceptions for individual projects because it's a very slippery slope as we see today.
Mr. Chair, if I could ask a legal question.
Thank you, Daniel.
Yeah, trying to protect against the unintended consequences of this. I've read through every single word in the Live Local Act. And while density is something that cannot be restricted, the words floor area ratio, which we use in our city and may be somewhat unique to our city, are not spelled out anywhere in the Live Local Act. And perhaps this just buys us some time until the new legislative session in Florida where they could amend this. But right now, as this law is written, it does not provide any state preemption that would restrict us in limiting FAR, which is how we de facto measure density in our city. So by ascribing a limitation on FAR, we can backdoor limit density.
So that's correct. And that's a great point. The Live Local Act does not preempt us. as to floor area ratio. There's no mention of the term intensity, which we define in Miami Beach. We measure intensity by floor area ratio. So, so the only things that the Live Local Act preempts us as to is density and height.
And then our next step would essentially be using our lobbyists as a city and our outreach to state representatives to make sure in the new legislative session, FAR is not included as a preemption, so we don't find ourselves back in the same starting point. So I think the first step is to make sure FAR is included in our local ordinances for
Yeah.
any of these projects coming before, because we could essentially restrict density through the measurement of FAR. And then the next step through our city commission, mayor, and the lobbyists that we use in Tallahassee is making sure any amendments to this bill do not add in a state preemption for FAR.
Anyone else on Zoom? Okay, and I would add to that, that hopefully they can find some carve outs for exceptions like Ocean Drive, like to put a building on an iconic street. But anyway, let me start with Gail. I'm sorry, I didn't mean to, I just want to get the public hearing. So I'm going to close the public hearing.
So I have one question about height, and then I have 4 suggestions how maybe recommendations we can make to preempt of the state. Okay, so the height, I don't understand the highest height within a mile. Does that include even non-conforming buildings, or is that just what's written in the law now? Because we have a building that's 518 feet. So does that mean
That's what's up.
the highest height can be 518, even though that's not our zoning law, 518?
Well, 2 things. What the Live Local Act says is that we cannot restrict the height below the highest currently allowed height. So it's not the highest existing.
So what is the
development.
highest currently allowed height in South Beach?
519 feet.
But that's not in our Mooney code, is it? As a zoning law?
It is, and there's a separate ordinance on this agenda that would address that.
Okay, so we would remove that so that no other building can be, I guess it's in the gateway overlay, anybody in the gateway.
But
So,
to that point, it
Yeah.
needs to be done throughout the city because we have a highest building in every part of the city. I mean, the massed development at 40th and 41st Street and Julia Tuttle Causeway, they were proposing that to be 20 stories. It was through the residents, we actively pushed back. It's now 8. But whatever the highest point is in Mid Beach, that needs to be addressed. And in North Beach, we've got a 22-story tower coming nearing completion. And we cannot, these developer exceptions are going to destroy the city.
so I have
We
a
need to
problem.
Protect against that.
And what
So-
I would just ask is if we have a separate ordinance on this agenda that relates to heights, if the board would like, I think we can answer those questions when we get to that item.
And that's where South Beach can be no higher than 150 feet, which I'm totally against also,
Correct.
because right now most of South Beach can only be 60 feet. Why would we? Okay, we'll get to that when we get to that. So these are my recommendations. Well, here's the most severe. We can do what Doral did, and we can put a moratorium on all developments for the next 6 months, for the next 12 months. If anybody has the appetite for that. I mean, we are overdeveloped. We do have a bunch of stuff in the pipeline. If we put a moratorium, I don't know if that would really hurt us much because we have so much development going on now.
I mean, a moratorium just gives us the time to think about what we're doing. It's. not
Yeah, and
stopping-
Doral did it for 6 months without hesitation.
Right. The fact
And
that
we have to
haven't done it yet.
like crawl on broken glass to begging for this, you know?
Agree.
Second of all, I was wondering, this, to prohibit all of these developments under this law, to prohibit short-term rentals, is that possible?
Well, remember, we're generally preempted from adopting.
So
new
are we preempt-
restrictions on short-term rentals in districts where short-term rentals are currently permitted. So.
But we did find a way around that where the developer would,
Well, what we have done, what I think you're referring to is the city commission has adopted zoning incentives for property owners who agree and record a restrictive covenant prohibiting short-term rentals on their own properties, and that makes them eligible for additional height, or in some instances FAR. So we've done that and that actually that's a good point, because something that we can do is if the city were to identify districts or where affordable or workforce housing should be incentivized, we can adopt incentives that are unique from what the Live Local Act provides. And I
Yeah.
think we have.
Mhm.
And in those instances, a development would have to comply with our code.
Okay, but as of now, you're saying that if we get a 150-foot or 500-foot Live Local Act building, they can turn it into half of it at 40% affordable housing, the other hotel or short-term rental or Airbnb. Is that what you're saying? We can't really preempt that unless we do extra incentives.
I think it would
'Cause I
it would
can't
depend
think
on
of
the
any
zone. It
way
would
to
depend
pre-
on the zoning district where
Yeah.
the project is proposed. If
All
it's in
right.
a district where hotel or short-term rental is permitted, then possible for a percentage of the units. Because under the Live Local Act, I think it's only 40%
Yeah.
that are required to be affordable for a period of 30
Okay,
years.
so that one's tricky. I don't know how to prohibit STR. Maybe we can come up with something. Okay, the other recommendation is recently they passed a law, the city, I think, passed a law where the average apartment does not have to be 800 square feet. All the apartments in the development can be the lowest square footage, which is 500 square feet. That's a gift to developers and incentivizes. If we go back to the old law, which is better for creating family housing, then I think that would help maybe limit these Live Local Act developments.
And I'd like to address that because the commission recently adopted that amendment as part of the resiliency code, but as a condition of, and I may need your help with this, but as a condition of being exempt from the minimum average unit size, a property owner has to covenant so that short-term rentals would be prohibited on the property.
Okay, so if
that's the
you,
only way you get that minimum average. Is it the average or the?
Minimum average, yes, but workforce and affordable units already have a reduced
Right.
unit size threshold of 400 square feet, and that's been in the code for many years now.
okay, so I didn't know that. So since they did pass the 500 square foot, then they have to not be a short-term rental if they take advantage of that. Is that what you said?
If they take advantage of that for the market rate units, they would have to
Right.
provide a covenant.
Right,
that
for the
they're not
market.
a short-term
Okay, that's
But
kind
the
of,
affordable units and the workforce units already have the ability to go down
right,
to.
that I
400.
understand. And a workforce unit obviously can't turn into a short-term rental, can it? By law? I mean, then the person can't be homesteaded and then come on. We don't even specify that. You can get a subsidized workforce housing unit and then turn it into a short-term rental, an Airbnb. Is that what you're saying?
Well, if it's a multifamily building, isn't that something that now the landlord would have an issue with the tenant where they would have to enforce the lease, which prohibits short-term rentals?
Well, the Live Local Act only applies to a multifamily rental development. So
That's the point.
it's not individual unit owners who.
Correct. So it's the landlord. So if the tenant is now taking their unit and putting it on Airbnb, the landlord would have to enforce the lease with the tenant.
That's right.
If
And
they
I-
choose to, if they choose.
Well, I know in New York,
Sure.
it is actually against the law to receive a subsidized unit that is
Yeah.
workforce or affordable housing and then go and rent it out on a short-term basis. That wouldn't be unique to Miami Beach. That would be presumably against state law.
I hope
I
it
hope
is,
that
but if
we
it's
have
not,
that.
we should definitely recommend that they
For sure.
make that a law. Okay, so 1, 2, 3. So I had one more. Oh, yeah, so I had one more recommendation. Since we think that the FAR increase is going to be preempted by Tallahassee. Maybe we should limit our maximum FAR now. So we grandfather in the maximum FAR. Because Tallahassee is probably going to say, okay, if you do a Live Local Act building, you can triple the maximum FAR within 1 mile. Right now, I think the maximum FAR is for the Wilsonian. It's like 3.5, something like that. I
I
think
think
that's,
it's 4.
I think it's 4. Yeah, it's something really outrageous that we thought it was only going to be for
3.5.
that. I voted against it because, and they haven't even built it yet, right? We've been waiting 4 years.
And, you know.
So
that's-
maybe we should, make a recommendation to downgrade the FAR. So if Tallahassee does triple it, it'll be only triple 1.0 or triple, instead of triple 4.0.
The challenge is we can't, the city is like any other municipality in Florida, a creation of state law, right? So we cannot preempt the state legislature from preempting us. If we adopted something like that, like a down zoning, setting aside the tremendous legal exposure that the city would face, the legislature could adopt a law that the maximum FAR for a Live Local project is 5.0, could be a number.
Right.
So we can't,
Okay.
I think the challenge is we can't preempt the legislature from preempting us. What we can do is ensure that these projects comply with our code. And where we think as a policy matter and as a planning matter, affordable and workforce housing should be incentivized, we can adopt our own incentives and attach, whatever conditions to those incentives that we want.
Can we say to a developer, you can either take advantage of our incentives or you can take advantage of Live Local Act incentives, and our incentives are going to be better, but is that what you mean?
That's one approach. That's one option.
All right, I'm done. Thank you very much.
Okay, Joe, any other, I know you want to make sure
Jonathan,
you,
go ahead.
okay,
No,
Jonathan.
I was just gonna say, so before us now is this proposed ordinance that it's either a thumbs up or thumbs down. I think in the time being, for right now, I think it's a thumbs up because it's necessary. So I think when we're talking about all these additional things, I think we're talking, we're gonna do this first, take a motion, I imagine, and then come up with the other recommendations. To Tanya's point, I would, add, as soon as the planning director receives, the application or whatever, it's on the planning department to notify the residents nearby. And this would be proposing a new, I guess, ordinance directing the planning director to notify nearby residents that this application has been submitted, and maybe even have some sort of part of the administrative process to hear them out. I don't know, I guess legally speaking, if it's administrative, whether you're able to really include, residents, but I think as much as possible, I think the consensus of the board is to include the residents in the process while keeping it quote unquote administrative. And so I don't know what staff would propose, but I mean, at a bare minimum, have them notified with a letter that explains what's going on and how they can find out more information, do a public records request or whatever it may be.
And even though I don't think we can require a public hearing, I do think, like on any other matter that is administratively approved, that, the public is free to write to staff or to speak with staff. And obviously, the only thing staff can do is review an application for consistency with the act and with our code. But it's not to say that a neighbor or an affected property owner loses their right to reach out.
No. The problem is the notice is one thing, and I agree with you. The problem is the remedy. There's really nothing. I mean, they can complain all they want to you, but if it administratively passes muster, So
Right,
it's kind of it doesn't really have teeth, but I agree that they should at least have not.
They should have
noticed.
not, I mean, listen, the
Right.
residents have their own set of teeth, right?
Right,
They
right,
can
right.
vote, they can reach out to the developers, they could express their frustration with the developers, so.
Right.
There's different way, they can negotiate with the developers.
The key is notice. They have to be aware.
The idea is
Yeah.
notice and transparency that this is about to go through the process. There's 90 more days until it's gonna be most likely be approved.
Right.
Because it meets the statute. Get to work, residents, do whatever you want to do, you know.
Correct.
Is there a
Right. So just to summarize his point is obviously memorialize the recommendation that whatever the strongest method or provision in the ordinance that we can apply that will give affected residents notice is important. To
And
finish that
Mr.
thought.
Chair, just as we're
Yeah.
making our recommendations to circle back on what we kind of discussed before, I would ensure that while we cannot restrict height and density, given that all other local ordinance must be complied with, that we would actually have the measurement of FAR. And I don't know if legal has given thought to that, if that would be one way to essentially circumvent the state preemption of height and density. I don't know if any of the land use lawyers here would be willing to offer their pro bono opinion on if that would be one way to essentially get out in front of the state preemption on density.
I think when you said pro bono, they all started laughing.
Well, any live local project would have to comply with the maximum FAR for that district. So it becomes a question of, I think.
Is FAR density?
No, it's not. FAR is,
Two different things.
and under state, by the way, under state law, FAR is how the city measures intensity. It's not how we measure density. But it's going to be a question of the financial viability of a project. If the same FAR applies to a market rate development as to a live local development, is it worth it for a developer to build a live local project, or are they going to build a market rate project?
I think our pro bono clock is running.
Sure. So it is a good idea, Joe, to try to work with FAR, but what I see happening is the authors of Live Local Act are not sitting there quiet, they're listening. And as this jurisdiction becomes more active, other jurisdictions they'll just take notes. And when the legislative session starts in January, they'll implement these changes. They'll make buildings that are seeking approval pursuant to this act immune to local regulations regarding building volume, they'll call it, instead of floor area ratio, which is a unique concept to Miami Beach. In Miami, they call it FLR. Here it's called FAR, but they'll say something like building volume. So, I don't think it was fair to take you all to task by the prior speaker saying that you all have not been proactive. You all are a reactive board. You respond to legislation that's being sent to you by the city commission. And you all could be proactive, but you don't know if only you have the support of the city commission, if you all would go first. So I think the way you all are constituted as a reactive board is totally acceptable. I think the real root of this issue is that in Tallahassee, it's going to be dominated by one party for many years to come. And that party is property rights oriented. So the real challenge here would be, why can't you amend the Constitution? Why can't you amend the Constitution to preempt the legislature? This is not for you all to do. This is more for grassroots activists to do, like the former speaker or the former caller. But, that is one way around this, because I don't see any actions that the local governments take, whether it's a county or a city. You cannot beat Tallahassee at this game. So, but you can beat it with an amendment to the Constitution, which would divest Tallahassee of this power and protect local historic districts, whether in a county or a city. So I think I don't want to be a Debbie Downer about it, but I feel that is
No,
a
you're right.
realistic approach.
So Michael, if you don't mind, can I ask some more questions on your pro bono clock?
It's running.
Don't worry. Some clients getting billed for
Yeah.
that.
If we were to do that, we're in the middle of a charter review year, so we could make charter amendments. Would those still be preempted by the state, even though they are our charter amendments to do X, Y, whatever it is?
Well, I appreciate Mr. Larkin's offer of free legal advice, but I can tell you that
Okay,
this year the legislature adopted a bill that preempts any local initiative or referendum process on a land development regulation. So we have to be mindful of that.
no, I understand
As to
that.
what we put in our charter.
I understand that, but if we, in our charter, just downzone the city, hypothetically speaking, I mean, it's a land use, so that we couldn't do that.
No, not in the charter, no.
Okay,
So when I use the word constitution, I know that people refer to the city charter as a quasi-constitutional document, but I'm talking about the state constitution, not any local charter, because it would be the same, like what Nick just said is absolutely correct. They'll just adopt a statute beating us down when it comes to trying to do things by referendum. They did it. So it's not the local charter, Tanya, it's the state constitution.
and for all the lawyers in the room, feel free to chime in the back. Is there, has there ever been a case or cases of municipalities suing the state and winning?
I mean,
Come on, you don't have that off the top of your head?
I think, well, first of all, I would say that the commission asked us to look at potential causes of action against the state. I will say that just to manage expectations, this law was drafted as a law of general application. It applies to all cities and counties throughout Florida. We have not identified an inherent defect in the bill as far as how it was adopted that might render it unconstitutional. Now, I know that there are other cities who are, and we've spoken with other cities who are looking at potential causes of action against the state, but we think that this can be most effectively dealt with through legislative outreach and lobbying our representatives in future sessions.
Understood. Point
And that's
taken.
same
But
note.
my-
Go ahead.
But Mike, even though it was passed and there are no inherent defects in the process, I would challenge that statement, but that's not.
Well, I mean legal
No,
legal
I know, I
infirmities. Yeah,
understand
yeah.
that. But even though it was passed properly, is there no precedent anywhere in the country where something that was passed is just so bad for the city that is forced to live under it? I mean, I don't know what an example would be, but like if they said everyone now living in the state of Florida has to cover their bodies in lead paint. I mean, it's a bad example, but we're like, no, that's a terrible thing. It's bad for us. Is there any example of any municipality taking on the state?
Tanya, I think the issue is sort of to Nick's first comment, which is that municipalities are a product of what the state tells us, what our
Right, but if
rights
the
and
state tells
laws
us
are.
that we have to kill our firstborn children, we're not going to do that either.
Well, there's a difference between the state telling you that you need to do that and the state telling a
Okay, so the state
municipality.
says to the city of, every city within its borders. So every city in the state of Florida says, we're instituting the Hunger Games here in the state of Florida. And we want to have a lottery every year. And we're going to choose 2 kids every year. And that's just what we're going to do.
Well, you'd probably have to go to the Supreme Court about constitutionality. I mean, there's got to be some.
But
Well,
that's,
there's federal law. Is
Well,
there
that's what I'm
anything for
saying.
the federal level?
I think just let's just take a step back. I mean, I think municipalities in Florida have home rule
Well,
and have had
not so
home
much
rule
longer.
since the 1970s. But home rule is qualified. Cities have home rule except as provided by general law. So that's why I think on this issue and on historic preservation and on many other issues, I think legislative outreach is going to be very important.
and I'm not saying we're not going to do that as well, but it's any track that is available to us. So it's making this good first step stronger. It's legislative outreach. It's building awareness. It's banding together with other cities. It's all of the things that we can do together. But if the state said, whatever state, let's say it's not even our state. What if in Wyoming, all of a sudden Wyoming said, we're doing Hunger Games?
No, Tanya, I understand your question, but you're asking if the city's willing to sue them. So I understand your point, but I think it's outside of the scope of what we're doing. We can make a recommendation that they sue the state. I don't know if that's plausible, but
I'm not. saying
I
that
understand
we
your
should,
frustration. No,
but
I understand.
just
I understand.
wanna know if anyone has done it successfully.
Right. I'll have to research that.
But can we please explain exactly? I mean, it's like the ordinance is like 3 pages long. Like, what are we voting on exactly?
So what this ordinance, I'm sorry, what this ordinance does is it creates, and if live local projects under state law have to be reviewed and approved administratively, this creates a process for that. It identifies the districts that would be eligible. It clearly states that every other requirement of our land development regulations would apply, including our design review criteria, our certificate of appropriateness criteria, and our conditional use criteria. I say that it's very important.
Right.
These are the
They're
criteria.
doing everything they can to minimize the impact.
And
of
these are
this
the
law.
criteria that our boards apply, right? So our board, not just our boards, but also staff on projects that can be approved at the staff level. So,
Right.
you know, the Live Local Act is clear that every other requirement of our land development regulations applies to a Live Local project. So, you know, the code needs to say that.
And what does this mean? Let's see, on page 36E,
It-
conditional uses, only conditional use permit applications for neighborhood impact
Right. That
shall be eligible for administration review. What about conditional use for outdoor speakers, hours of operation?
That would not be eligible for administrative review. That would have to come to the board.
Right,
Right.
that doesn't. change.
Oh, okay, so,
These are, the neighborhood impact structure is a building over 50,000 square feet. We just
Oh.
gave it a word so that we don't have to say.
yeah, I didn't know what that word meant. Okay,
And neighborhood impact lot is a lot over 20,000 square feet, which in certain districts is a conditional use. I believe the I-1 district, that's a conditional use. And so what this is saying, those are the only two types of conditional uses that are necessary for the construction of a building. Any other conditional use permit that's in the code is for a specific use, be it
right.
a large entertainment establishment, an outdoor, whatever the case may be, it's not necessary for the construction of a building. And so we are making it clear that if I'm proposing a Live Local Act project and I want to put a nightclub on the ground floor, that nightclub would still require
Okay.
coming to the planning board and
Okay, I
not be
understand
eligible
now.
for the
Okay, because
administrative review.
okay, now I understand. Okay, that's good. So I think I do agree with these zones on page 35. I think this is okay.
Yeah.
Are we missing anything? No?
No, and Yashil, I want to give him an opportunity to speak. Go ahead.
Yeah, just a few quick questions. So the technical definition of neighborhood impact structure, neighborhood impact lot is what?
The neighborhood impact structure is a building over 50,000 square feet.
Mhm.
And the neighborhood impact lot is a lot over 20,000 square feet. And there are certain districts where those are conditional uses.
Got it. Okay, next question. So for administrative approval, that has to be approved or rejected just based on technical, I guess, zoning code, or
Compliance.
can it compliance, or can that?
Technical compliance.
It's just technical,
Yeah,
right?
yeah.
That
Technical
involves-
compliance, we do have the criteria, which is somewhat.
Right, his point is you
know,
don't have
yeah.
discretion.
You don't have
They
discretion.
either
It's not
comply
like
or-
it's,
right.
it's not like it's subjective. It's
Correct.
absolutely objective.
Correct.
Correct. Okay. Next thing, is there any way within Live Local, in other words, it seems like it is what it is and the city is, I guess, is somewhat handcuffed, right? So, but at least within these, definitions, can the city say, hey, if you're gonna have 40% workforce housing, the other 60% of the building can't be X, Y, and Z. So you can't have someone that comes in, gets this height for a beautiful condominium project, and then you have the rest of the units that are 40%. Is there any way that the city can at least say that? So if people are going to be taking advantage of this, at least the city can now get, some type of living supply for its residents instead of these other buildings, which are rather unattainable.
Well, what the Live Local Act does say is that for mixed use residential projects, at least 65% of the total square footage must be used for residential purposes. I guess, are you
Sure,
asking?
so residential, I think, would also, or condominiums would also fall under the residential use, no?
Mhm.
Right, so what I'm saying is that if someone takes advantage of the Live Local Act, can we say, hey, instead of the other, 60% of the building, whatever gets to 65% would be condominium versus multifamily. And this might be a way to get, rental housing into the city, which otherwise.
He's
is
saying,
sort of
can you
lacking.
mandate what they do with the remaining 60%? Basically,
I think we can, I think the zoning district regulations as far as what uses are allowed in that district would still apply.
oh, okay.
But I don't think we can distinguish between multifamily and condo, because at the end of the day, that's just a form of ownership. It's not a different use. It's all residential. But I do think that the use regulations for a district would otherwise apply.
But there's nothing, in other words, so right now, it seems like people are getting a significant amount of benefits. So there's nothing that we could do kind of proactively to try and say, hey, the city needs a place for people to be able to live. Instead of condominium, it's multifamily. We can't, I guess.
I don't think we can
proactively, but I
regulate the ownership style if it's condominium or rental.
Well, we
ultimately,
technically can because we're saying that 40% has to be workforce housing,
Well,
which
the
is
law
right.
says that.
that
Fair,
40%,
but that
yes.
40% is saying, hey, the form of ownership has to be, multifamily and not condominium. So someone is mandating on the 40%. Is there any way to say as a city that, okay, and the other 60%?
I don't think we can regulate the owner. In fact, we're specifically preempted from regulating how residential property is owned.
But the state could do it, but we can't. Because that is what the state is doing by saying 40% is workforce housing,
Well,
multifamily form of ownership.
What the state has done is create an incentive for multifamily rental development.
But in essence,
correct.
they have. But anyway, the answer is, yeah, we can't do that. I mean, if they can, you'll look into it, but I don't think we can do that.
Okay.
Yeah, and then I want to at least get this motion passed, and then we can add on to the recommendations. Go ahead, Tanya.
Can you explain who regulates this law would be adding a great number of units and additional density to our city? Who is in charge of requiring that the infrastructure is upgraded, not just the tie-in from the particular building, but the entire line of infrastructure that this deals with? Because we see sewer line breaks and water main ruptures all up and down the line, regardless of where a project is, that have devastating consequences for the city or neighborhoods. And for developers who come before us with projects, well, not before us anymore, before you, saying, oh, no, we're gonna tie into the city, it's gonna be fabulous. But that doesn't help the neighborhood 4 blocks away that's going to be affected by 4,000 new toilets flushing. Who's in charge of that?
So the levels continue to apply as part of the building permit review. Concurrency for level of service for water supply, for water capacity, for sewage still applies. And if there's not capacity in a particular area, the building permit cannot be approved until improvements are made to the sewer lines.
And who's responsible for those improvements?
Well, there's many options. The developer can pay to make the upgrade if there's no plan at the local level to have that upgrade done.
Okay, hold that thought. Why would we spend our tax dollars to replace a sewer line that's working just fine for what exists now? If a developer wants to put in 12 times the units, I don't want my tax dollars going to subsidize that developer's project. If that developer wants that project, then that developer can do the lines. I would rather use my tax dollars for underserved areas of the city that have the same issue, but nobody wants to do anything there. So how do we put that into this?
Aren't there fees that developers pay? I mean, it's usually the
Yeah, but-
impact fees.
But to how great an extent? Because
No, what I'm saying is that, so they pay fees, so shouldn't those fees kind of pay for these upgrades
They would
from the
they would.
developer? Not,
Yeah, they would.
I
but
think that's how they get paid for. Not through our tax dollars, but through the developers' payments.
no,
An
I
impact
understand that. But I'm saying an impact fee for one project that is going up, 10 stories is very different from impact fees of a building that's going to be 20 or 40 stories.
No, but I think the fees go up.
Go
is
up
what I'm saying.
commensurately.
Correct. They
That's right.
go up.
And-
Yes, they do.
Additional
But so
density.
then who manages the process of where that money goes and how it's spent and how quickly? Because what we've heard on other issues where there are fees incurred by developers in lieu of, that it goes into a general fund and may or may not get used for something. Like, I just want to make sure that if there are impact fees going to upgrade the infrastructure, that gets done before the first shovel hits the ground on the building,
Well,
not afterwards.
impact fees, or the use of impact fees is restricted by law. You can only use the proceeds of those fees for eligible projects. So
Okay, because we heard it with the, what was it, with affordable housing, when somebody said, I'll donate to, or I'll have an affordable housing. I can either build more affordable housing units as part of this application, or I can put money into an affordable housing fund. And we learned, I don't know, if it was last year or 2 years ago, we had this whole discussion that money didn't necessarily get used for affordable housing. It got used for who knows what. But that, I guess that's a different legal definition of that fund source and use. But so my concern is that whoever's paying for it, whatever is mandated, that nothing gets built unless we have the capacity for it. And if we don't have the capacity for it, that capacity gets built to all of the affected areas, not just that one street, but anybody downstream of that, because no pun intended, poop flows downhill, and that's what's going to happen. And we have such a problem with this already in our city with the development that we have, that this exponential growth will be disastrous. So I don't know how to make sure that gets strengthened, but I want to put that out to you guys.
I mean, the law says if there's no capacity, you can't build. So the capacity has to be there for sewage and water. For other things, there's more time. It gives you 3 years after a project is built, but for sewer and water, that has to be in place the day that the building is occupied. So that's part of.
And the law says specific to how far downstream.
Well, you can't affect someone else's level of service if the capacity looks at everything. So if there's no capacity, your project cannot move forward. It doesn't say that if there's capacity for me, but not for the neighbor, it's there has to be capacity, period.
Melissa, do you have any?
There was something that I was reading when I was trying to understand it better, where it refers to that for projects to qualify, they have to be consistent with the comprehensive plan. So can you just explain to me like what the comprehensive plan has that would be applicable beyond what we spoke about today?
The comprehensive plan has a lot of general rules that everything that the city does has to be in compliance with. So everything that's in the land development regulations in the zoning needs to be consistent with the comprehensive plan. Comprehensive plan has limits on density, on intensity, on uses. They're more generalized than what's in the zoning ordinance, but everything that's in the zoning ordinance needs to be consistent with the more generalized regulations that are in the comprehensive plan. The comprehensive plan also has a level of service for public facilities, for parks, for different types of park facilities, for stormwater capacity, for sewage capacity, for potable water capacity, both in terms of the amount of water that's provided and the capacity in the lines. There's levels of service for that. It has goals that we need to comply with, be it for resiliency, goals for affordable housing, goals for other capital projects that we may have in the city. And so it basically guides everything that is done in the city.
So, and believe it or not, but I have read the comprehensive plan before, but so it is the second thing that's brought up as being to be qualifying is in line with the city's comprehensive plan for these projects to get through and skip the permitting. So is there anything that we can be affecting in the comprehensive planning that would sort of help us, in protecting ourselves?
We recently did an update in 2019 on the levels of service. I know our consultants worked with Public Works and Capital Improvements Department to make sure that the levels of service were correct and what they should be. I suppose if we get additional density that was unexpected, maybe that does need to be looked at again, because it's based on our previous density, and now the state unilaterally increased the density in districts that had a lower district. For example, the MXC district, the density limit was 100 units an acre. Now for a live local project, it's 150. So it probably would make sense to just discuss it with Public Works and make sure that that what's there.
It's the angle if
Yeah.
we can tackle the comprehensive planning in a way that we can deflect some of
Mhm.
what this is trying to do.
I don't think we can use levels of service to stop growth. It's ultimately, if there's a level of service and the developer can pay to increase that level of service, we have to allow it. We can't tell them, no, the level of service is this. You can't, there's no way for it to be increased. If they're willing to pay for it, we have to be able to work with them on per state law. It's not intended to be used as a tool to
Right.
stop development. It's a
Right.
tool to make sure that development can be managed and handled.
Got it.
All right, so I'm assuming you've taken notes of some of the
Mhm.
thoughts and recommendations. So can we get a motion to on this item to approve it? Gail, you want to move it?
I make a motion that we agree with staff's recommendation to pass this ordinance.
Favorable recommendation.
Favorable, yeah.
I'll
Okay.
second.
Okay.
Okay, we have a motion by Ms. Durham.
While adding
Second
the
by Ms. Bond.
suggestions we made, or?
Not yet. We're gonna,
Separate.
yeah, let's just pass the ordinance. It's a no-brainer to pass it to start with.
Okay, roll call.
Tanya seconded. Sorry, go
Okay.
ahead.
Ms. Beatty,
Yes.
Ms. Bott,
I hate the fact that we're having this conversation, but yes.
Mr. Cement,
Yes.
Ms. Durham,
Yes,
Mr. Elias.
Yes.
Mr. Frieden,
Yes.
Mr. Magazine,
Yes.
motion passes.
Okay, and just for informational, I don't want to belabor this, but until this passes, what is like, for instance, we know the Clevelanders making up, how is the process doing prior to this ordinance being in place?
It's not.
Because they claimed in the paper that we wouldn't, that they would not be subject to whatever we did today. So I'm just curious, what happens now prior to this being in place?
The mere dropping off a box at City Hall does not vest a project. So under our zoning in progress ordinance, once the planning board transmits an amendment to the LDRs with a favorable recommendation, that amendment is enforced against new applications unless
Is that considered a new application? The Clevelander?
well, unless a property owner has a building permit or a land use board order.
Oh, okay.
So you know, anything that was submitted yesterday, and by the way, I've not seen anything. I believe it was submitted at around 3 o'clock to the planning department.
Almost 4, I think.
Okay, so it will be subject to this ordinance.
That's correct.
Okay, great. Okay, so we passed that. I know Gail, Jill, everyone had some thoughts. Tanya, were you able to memorialize them concisely so we can make these recommendations?
I have direct the planning director to notify residents that an application has been received. Review levels of service for infrastructure are the two main ones that I have based on the discussion. I don't know if
we
they're,
want to consider a moratorium on development. I mean, I don't know if we want to vote. Yes, there should be a moratorium, but I would like to propose that the commission consider it so that we have more time to.
I can respond to that. Zoning moratoria are first of all, they're subject to legal challenge. But they are temporary in nature. The purpose of a moratorium is to preserve the status quo while in this case, the city studies potential or necessary amendments to the code. They are a pretty significant restriction on a property owner's property rights. And I think in this context, my biggest concern would be that the way the Live Local Act is drafted, qualifying projects are, if they check all the boxes in the statute and check all the boxes in our LDRs, they have to be approved. So I would recommend, rather than pursue a moratorium, that the board, which you just did with the administrative site plan review ordinance, and you're about to look at an ordinance that would modify heights in South Beach. I think that exercise is that's what, under normal circumstances, the city commission could impose a moratorium for, is to look at what rules, what amendments would be appropriate. In this context, you're already doing that. And I think that's a good thing, because the way the Live Local Act is drafted, it is drafted as, if you check all the boxes, you're entitled to administrative approval. So I would not recommend a moratorium.
Okay, I know it's drastic. I accept your answer. Imagine if every municipality did a moratorium, then we would have Tallahassee hold hostage.
It prevents us from doing moratorium.
All right, we just want to, come on, go ahead. We want to get these recommendations. Go ahead.
I don't accept your recommendation. No, I love you, but I don't accept that because we have a new commission coming on board. We've got a couple of months missing. The commission needs to spend this time, and at the last commission meeting, the planning board declined to pass favorably an upzoning of somebody's house. And the mayor said, we don't care what the planning board said, we're going to do what we want anyhow until the 11th hour. So I think, I understand that a moratorium can be seen as draconian, but it's not. It's a 6-month pause while we all get our ducks in a row and figure out what best way to proceed. And people are spending millions, tens of millions, billions of dollars in development here. And the idea that we don't want to take a 6-month pause and measure twice and cut once to make this as correct as it can be for our city, given the limited options that we have from a state. Nick, I love you to death, but I don't accept that recommendation. I really, really urge my colleagues.
What about a 3-month moratorium?
Okay. I just have to be very clear with the board because I think that the Live Local Act is written very clearly, and I can't advise you to do anything that would violate state law and expose the city. So the Live Local Act starts with a municipality must authorize qualifying projects, right? Multifamily and mixed use residential as allowable uses.
But
A
what
municipality may not restrict the density below the highest allowed. A municipality may not restrict the height of a proposed development authorized. A proposed development must be administratively approved. So my best legal advice to you is that you adopt rules that will allow the city to effectively review projects that claim incentives under the Live Local Act. Because my concern is that well, I don't want to state my concerns on the record, but I would not recommend pursuing a moratorium in this context.
Even if a moratorium was enacted, wouldn't anything that kind of applies under Live Local just circumvent that? Because
Well, that's why I read those.
It would preempt it.
That's why I read those sections, because my concern is that the language in the Live Local Act is mandatory.
But other cities have done it. I mean, Doral is not a bastion of liberal, progressive, limp-wristed preservation. Other cities have done it, and we are not saying that we won't do what the Live Local Act says. All we're saying is we would like 5 minutes to think about it more than an
All
hour
right,
on
well, the bottom line is all we can do is recommend they consider it. So
So can we recommend that they consider it? And then you can have the same conversation with them saying that you don't recommend it, but at least can we put it out for discussion?
what are your
I
thoughts?
think that's,
Nick, be
I think that's,
candid.
no, I think that's an issue for the board to discuss.
Okay, I mean,
Well, I mean.
I really want to move on. Does anyone have strong feelings about recommending a moratorium either way?
It's not a light decision. I mean, we got to be consider.
Well,
what-
again, it's simply
Right,
yeah, I
right,
understand, but it's simply a recommendation
Yeah,
that
but
they
every-
consider it.
You're putting a recommendation in motion of something that we're not understanding the whole impact.
All we're doing is asking the commission to think about it. We're not putting anything in motion other than,
Right, but
have
that being
conversations.
said, if the city attorney thinks that would lead to exposure, then you got to think about that. But I guess I don't see why they can't have that same discussion at the next level, to your point.
Mhm.
Yeah, I mean, I guess that's where I'm between a rock and a hard place, right?
Right.
Like, I actually agree with Tanya's concept. But Nick couldn't have been clear that I strongly recommend not doing this.
All right, so how about we make these recommendations and it'll simply be that the commission explore,
To the extent permitted by law.
correct, that they explore the possibility of a moratorium to the extent it's not, violative of the act.
The only thing I want to make sure we're doing is highlighting to what to me is one of the most important things, which
The
is
public
the
notice?
public.
Yeah, we
notice.
got
So
that.
I don't want it to appear in a package to the
Right.
commission.
Got it. I think that was the first thing you, or the second thing, first. thing
That's
you
what
marked down.
Weston did. I think Weston required public hearing prior to any.
Yeah, I don't know if they can require public hearing, but they can definitely require notice and ability to be heard. I don't know if that's to be a formal public hearing. but
Raheli, can you read?
Bottom line is to the maximum extent possible for public involvement is what we want to encourage.
And if Weston has required a public hearing, I'd like to model our recommendations on the strongest best practices that other municipalities have put into place to deal with this. Because we don't need to reinvent the wheel if other cities have required something or, let's figure out what they've done and incorporate it and as
Well,
recommendations.
can't we use the planning board as the hearing, but it's just for a hearing.
We
It's
cannot
nothing
require a
legally-
public hearing.
No, you can't.
But it's not legally binding anything that, it's just like a town hall meeting, kind of. They come here like a town hall meeting, no? Okay.
Can we maybe kind of to do something directing staff to bring us in the next, couple months, a kind of review of how other municipalities have dealt with the Live Local Act and in terms of notice, like Mr. Cement just mentioned that Weston's proposing a public notice provision. It's not, a hearing, but it's public notice, but maybe there are some other things that other municipalities are doing that would be a great addition here.
Right, but
we
at
can do
this
that.
point, our hearing will be over. So the recommendation would be that you do that
Mhm.
and present it to the commission.
I do think with regard to to notice, because I'm hearing that there seems to be consensus on that point.
Yeah.
Is if the board wants to transmit a recommendation that the commission look at including a notice requirement, do that, I think that recommendation should be for this item and we'll
Yes, we'll
research
do
it
it.
between now and first reading. And if we can, we'll include
Right,
it.
that's what we're doing.
Yeah. Yeah.
Okay. All right, anything else?
Riley, can you just read back where we are and what we're recommending?
I have direct planning director to notify residents that an application has been received to the maximum extent possible. Review levels of service for infrastructure due to density increase. That the commission explore the possibility of a moratorium to the extent permitted by law. And then review other municipalities' ordinances and report to the city commission.
How about the
And-
FAR inclusion?
I just have a quick comment on the notification to residents. I think, beyond having residents having a voice, so that's why something at town hall where there's no power to it, is just them getting to voice something that we can't do anything about it. When you guys are doing the notice or you're recommending to do these notices to the residents, is there information that's provided that allows them to figure out next steps? I just find that oftentimes when residents do want to be proactive about doing something, they just don't know who they're supposed to contact. So
And that's a great question. What we include in other notices is contact information. I think we have a phone number and an email address for the planning department. All of these documents, anything submitted is a public record. So the public has access to them,
Mhm.
right to see them. And if they see something that they think doesn't comply with the Live Local Act or the LDRs, they're certainly free to petition their government like anyone else and write to staff or call staff.
all right, just I guess this isn't a simplification for them to be able to be quickly figure out where to go next.
Well,
right?
and that could be, and maybe it's something staff can explore is could also be a link to, any plans that are submitted as part of our permitting system.
Yeah, I think that would be a great addition. I mean, most people don't know anything about
Mhm.
that a public request is a thing that they could do. They've never heard of it, so that would be great.
Rahelia, I'll let you find the best way to word it, but if we also included the FAR discussion that we had.
FAR be included. Sure, we can probably just clarify in,
That FAR is not exempted. under
yeah,
the
in
Live Local Act.
2556D, compliance with the land development regulations. No development shall be administratively approved unless and until the planning director has determined that the site plan complies with all applicable land development regulations and not preempted by the Live Local Act, including floor area ratio.
So that add to the recommendation. Okay, someone want to move those recommendations?
I'll move on.
Okay, Tanya moved it, second, someone?
I
No?
second it.
Great, okay.
Motion by Ms. Bott. Second by Ms. Durham. Rex. Okay, roll call, Ms. Beatty,
Yes.
Spot,
Yep.
Mr. Cement,
Yes.
Ms. Durham,
Yes.
Mr. Elias.
Yes.
Mr. Frieden.
Yes.
Mr. Magazine.
Yes.
Motion passes.
Okay. Next seemingly companion amendment, planning board file 230631, South Beach Development Regulations on page 39.
Okay, so this is also related to the Live Local Act. It primarily focuses on the land development regulations in the South Beach District, particularly south of 23rd Street, which is the northern limit of the architectural district, which is the National Register Historic District, that covers the South Beach area that was designated in 1979. So the ordinance does a few things in terms of modifying setbacks, development regulations within the South Beach area. The first thing it does is it amends the height limits of the RM3 district located south of 23rd Street. It changes the height limit from 200 feet to 150 feet. While the RM3 district is not subject to the Live Local Act, so you can't do a Live Local Act project in the RM3 district, because the height limits apply within a mile, this height limit would apply to other projects that are subject to the Live Local Act district regulations. So this reduces the height limit to 150 feet. It amends the CD2 development regulations for Washington Avenue. So the first thing it does, it is establishes a front setback requirement of 110 feet for the portion of buildings located above 75 feet in height. Currently, projects on Washington Avenue can be developed up to 75 feet. They have a whole series of setbacks. This creates a new setback requirement for the portion of the building located above 75 feet in height that needs to be set back 110 feet from the front property line. It establishes a minimum side facing a street setback requirement of 45 feet for the portion of a building located above 75 feet in height. So that needs to be set back 45 feet from the street. So that basically, if there is going to be a tower, that tower needs to be far removed from the frontage of the street so that it doesn't impact air and light going down to the street. And also minimizes the footprint of the building. The next thing it does, it establishes an interior side setback requirement of 45 feet for the portion of buildings above 75 feet in height. So between the interior property lines, there needs to be an additional setback. So you need to have a 45 foot setback from the side street, from the interior setback, and then 110 feet from the frontage. The next thing it does is for the Alton Road Gateway area of the CD2 district, it reduces that height limit for main use residential buildings from 519 feet to 150 feet. The next thing the ordinance does, it amends the MXC development regulations. The first thing it does is it increases the tower setback to 110 feet. The tower is the portion of a building located above 50 feet. So if there is going to be a tower, that needs to be set back from the property line 110 feet. It increases the side facing a street tower setback for lots greater than 100 feet in width from the current requirement is 10 feet of the lot width plus 5 feet to 25% of the lot width plus 5 feet for non-oceanfront properties. It increases the minimum side facing a street tower setback for lots less than 100 feet from 5 feet to 45 feet. It increases the minimum interior side tower setback in the architectural district from 5 feet to 25 feet. Increases the minimum rear tower setback facing an alley, currently that's 0 feet, increases that to 10 feet. And then establishes a maximum lot aggregation limit of 2 contiguous platted lots. So this is consistent with the development pattern in the MXC district. The historic buildings generally don't occupy more than 2 contiguous lots. So this says a unified development site cannot be aggregated that is larger than 2 contiguous lots. So that limits the amount of FAR that can be utilized in the amount of floor area that can be utilized in a development so that any new development is consistent with the development patterns of the district. And so those are the main things that this ordinance does. The tower setbacks are, as I said, they're intended to make sure that the tower has a minimum footprint. It's not intended to stop a Live Local Act project from being developed, but it makes it so that the tower doesn't impact the surrounding properties to the extent feasible. And then for the height limits, we do have concerns with the height limits and reducing those height limits. It can create nonconformities. So existing buildings that are 200 feet would become nonconforming buildings. So if there is a proposed remodeling of those buildings or renovation of those buildings, they could run into issues depending on the value of that renovation and triggering our nonconformance limits. There are also issues with proposed developments in the height, given the existing FAR limits of 2.0 in the architectural district. If we're limiting the height to 150 feet, that could result in a squattier building that may impact air and light more so than a taller, more slender tower. So there are issues with that. Staff does have a favorable recommendation for the portions of the ordinance related to setbacks and lot aggregations. However, we recommend that the planning board transmit an unfavorable recommendation related to height limits. We do think that the setback and lot aggregation limits can provide a good amount of protection to ensure that anything that's developed under the Live Local Act will be compatible.
Can you talk a little
So-
bit more about the concerns for the height? Like, give us some examples of what we're referring to.
So we have some existing buildings that exceed 150 feet, and if they were going to do a major renovation that exceeded 50% of the value of the building, that would be a non-conforming building. Technically,
They won't be able to.
they won't be able to.
Right.
We could run into limits, and then it'll cause us to do more code
Could you
amendments to
not,
allow.
could you not grandfather them?
Specify for people doing renovations or somehow earmark that.
The height is not
specific-
applicable. Yeah, we can look at that.
Well, or yeah, just grandfather
Yeah.
existing buildings. Yeah. Okay.
Or how about, it seems like the overall sentiment from the entire city, including the existing commission, is to go more towards residential. About exclude it if there is a transient usage such as a hotel, short-term rental, you would waive that requirement if the renovation is being to adapt the building to a residential.
Yeah, mark down, but hold on, so I'm consistent. Let me just, are you all finished with the presentation?
We are. yeah.
Okay, is there anyone here in chambers to talk on this? Just want to get the public hearing out of the way and then we'll talk about it. Mr. Larkin?
Yes. Good morning, Mr. Chairman, board member staff, Michael Larkin, 200 South Biscayne Boulevard, here representing the Surf Comer Hotel. That's just north of the SLS Hotel and just south of the Marseille Hotel. I'd like to discuss with you the portion of the ordinance regarding height reductions in the R3 zone. Just bear in mind that it is 200 feet now if your lot size is 115,000 square feet or greater. And that's not as of right. You know, there have been applicants coming to the board. The Shore Club did get 200 feet, but the Raleigh assemblage, for instance, got 175 feet. The Ritz-Carlton was recently approved 183 feet. So it's really up to the Historic Preservation Board to determine what is compatible with the existing surrounding neighborhood. And there are already setbacks in place that are substantial that also enhance compatibility. The minimum setbacks are 100 feet from Collins Avenue, 100 feet from the beach walk. The Ritz-Carlton that was just approved, that attached addition was actually set back 300 feet from Collins. And in order to obtain the approval, we agreed to an additional setback from the beach walk of 15 feet. So those are already in place to deal with any type of potential issue that could come with height. There's also another mechanism called floor plates. The floor plate is just each floor going up has to be a minimum size or a maximum size. Under the code, it could be 15,000 square feet or greater. The Ritz-Carlton Tower, for instance, was only 8,000 square feet. So that's yet another tool you all have in order to determine compatibility. And what Rogelia said is true. These towers, the Shore Club, the Raleigh, the Ritz will all be rendered non-conforming even before they're built. And that makes it much more difficult to obtain financing for a construction loan or even a refi on down the road. There is a concept in place called blotto tourism that Richard Florida coined for Miami Beach, that we're oversaturated in tourism in our city center, that there's not a healthy, balanced neighborhoods. You know, it's these additions that are coming online now that will make the city center more balanced because it's actually losing population now because apartment buildings are being converted to either short-term rentals or hotels. So your population is declining in the city center. So this is one way to counteract that balance and try to have a more well-balanced neighborhood rather than one that's oversaturated with tourism. The last 2 points, what properties does this affect? So the way that the ordinance is drafted, it says south of 23rd Street, the height drops from 200 to 150 feet. But if you look at that east of Collins, what does that really affect? It doesn't affect the W Hotel. Then there's a parking lot. The Bulgari Hotel has its approval. The Satai is not going anywhere. The Shore Club got its approval already. Then you have the Nautilus and the Shelburne Hotel, which are already non-conforming with regard to their built floor area. They have no surplus floor area. They're not going to be aggregated together. Then you have the Raleigh assemblage. And then you have the Marseille, the Surf Comer, and SLS. Those could be combined. That's really the only set of properties in this whole stretch that will be harmed by this height reduction. Because after that, you have the Delano and the National. Each of them are non-conforming with regard to their built floor area. They can't be combined. Then you have the Ritz that's already got its approval, the Deco Plage, and the Lowe's. So really, it's the Surf Comer and companion property either side. That's the only properties that will be harmed. And what staff has right in this ordinance, they're looking at the MXE district and they've increased setbacks in the MXE district. They've created a lot aggregation rule that says no more than 2 lots. I urge you all to look there in the MXE district, for instance, parking requirements. In the historic district, you can pay a parking impact fee and not provide parking on site. Perhaps you remove that in the MXE district as well. I just think that you're harming other properties unnecessarily in efforts to try to get out from under the Live Local Act. And I just wish you all would consider the harm that could be done. Thank you.
Thank you. Graham, are you speaking on this? Okay.
Morning, everybody. Going to bore you with some excitement about Florida statutes. Just briefly, as you know, part of the package here would modify the maximum height in the Alton Road Gateway area. We talked about it already at the last night. The 500 Alton project, 5 Park, is subject to a development agreement under Florida statutes. So under the terms of that development agreement and under Florida law, that project and anything built under it is subject to the regulations that applied at the time of the development agreement. So it is impossible for the city to subsequently amend the code to reduce the height of that development. So I just want to, and Mr. Clergis and I talked about this yesterday, just wanted to put that on the record that development agreement, not just the project, because, you know, what Mr. Larkin was talking about is that there are projects that are protected because they have a development board order, which is one thing. And if that order expires, that protection goes away. The development agreement, to the contrary, doesn't rely on a development board, a DRB order, or a planning board order to protect that development. The development agreement itself does. So again, just for the record, I want to make it clear that there's nothing in the event that this board recommends and the commission moves forward with a reduction in height in the Alton Road Gateway overlay, that cannot in any way impact development under the terms of the development agreement for 500 Alton. So that's it. It's a pleasure seeing everyone.
Graham, can I ask you a question on that?
Sure.
However, let's say where the hostel is, right across 8th Street. Or call it whatever you want, Machialina. Right, whatever property is right there along 8th Street.
Mhm.
If they would decide to essentially say, okay, we want to construct a tower now, if we did not have this reduction, they would essentially be able to construct up to a 519-story tower. However, if we would move forward with this reduction in the Alton Road Gateway area, whatever was built at Machialina would only be able to reference the 150-foot height limitation as opposed to allowing a 519-foot building on 8th and Alton.
Yeah, the power that the Live Local Act would give to utilize the height under the Alton Road Gateway overlay goes away when you reduce it, right? And I think, as you noted at the last item, FAR right now is your limit, is your maximum limiting factor. That wouldn't even, you wouldn't come close to hitting that height. But yes, you're correct that changing the 519 not for that development, but for the surrounding radius would have that impact. Thank you.
But I have a question for you, Graham.
Sure.
The development agreement that you speak of for the property 700 block Alton Road, has it been signed?
So what I'm talking about is the existing 500 and 600 Alton development agreement. There is as we've seen, we are processing.
No, but that doesn't include the property that you're talking about. The property you're talking about is 720 Alton Road, and that development agreement has not been signed. So you are 100% wrong.
Well, what I'm talking about.
We can reduce it to 150. It doesn't, you're wrong.
I'm not disagreeing with you as to the 710, 720 Alton project. That is in the middle of an approval process, right? We've already on that development already agreed to cap it at 150. But the reason I'm boring you all this morning is about 5 Park 500 Alton, the tower that's been topped off. That is protected under the terms of the development agreement. I'm not suggesting in any way, shape, or form that the redevelopment on that we're contemplating on the health center property has an existing development agreement or is protected under a development agreement. It is not.
And
What I'm
we-
talking about is the existing one that was approved 3 years ago.
And we agree as to the existing development agreement under both the state
Yeah, that's
Development
fine.
Agreement Act and the.
If
Yeah,
they wanna-
I don't understand the relevance of that. Like,
There's no
whatever.
relevance because it hasn't even finished being built yet. You're talking about 200 years from now, maybe it has to be rebuilt.
Well, the only reason I'm bringing that up.
Yeah.
Other than visiting everyone this morning and having a pleasant time, is that
Thank you.
is that under the terms of state law, that building, once it's complete, will, and say, the city goes forward and reduces the height.
Oh, that'll be non-conforming
It's not legally non-conforming, it's legal, right?
because of the operating agreement.
Because the
All right,
development.
but that's an operation of law. So I don't know all I'm saying is I
Again,
don't know what the
I'm saying you
relevance.
Have to do anything. I'm just making it clear.
Okay,
that-
all right.
Graham, are you worried that we're gonna ask or require it to be cut in half?
Well, if you could, Tanya, I'm sure someone would. I mean, if Daniel's still listening, I'm sure he would suggest that. But yeah, again, all I'm
No.
doing is putting it on the record that that's what the
Right.
rules are.
Got it.
That's
We
all.
understand.
Thank
And,
you.
and the non-conforming use is a concern, but I think that we'll try to come up with ways around it. But by operation of law, you're saying you can't be determined non-conforming regardless of what we do. So it's
They're in the
irrelevant to
terms of
us.
the development.
Okay,
correct.
got it.
Thank
All
you.
right. Anyone else? Anyone on Zoom?
We have
Daniel
Seraldo on Zoom.
Okay. Daniel?
Yes, thank you, board members. Daniel Seraldo with Miami Design Preservation League. Now, this particular ordinance was referred by the mayor and several of the commissioners trying to be proactive instead of reactive. Once again, disappointing to see our planning staff twisting itself into a pretzel to try to say that 519 feet could in any way be a compatible new development throughout our low-rise city. Even with the latest Clevelander proposal, we should all remember that what is proposed as housing is east of our coastal flood construction line, putting more residences at risk of hurricanes and increasing natural disasters. I will pledge today that we will not ask for Fifth and Alton to be demolished. I think if anything, it is now a permanent landmark for what not to do. But so Graham and his client can rest easy, but we must move forward with these tweaks. We must get our planning department more aligned proactively in doing what our taxpayers need, which is protecting our city. And the final thing I want to say is the prior lobbyist said that the Republicans are in charge and that it's going to get even worse. You know, there's been a backlash already. We have Republican cities around the state, Doral, Weston, et cetera, that are saying, no, we don't want high rises in the middle of our neighborhoods. So I think it's not right to think that all Republicans believe in this. This is an extremist fringe movement, and we must continue to be brave and move forward. Thank you so much.
Thank you, Daniel. Anyone else on Zoom?
No one else is on Zoom.
Okay, let's close the public hearing. Gail?
I have one question for staff. 720 Alton Road, which is what I was talking with Graham about. Is that the height there is now maximum 60 feet according to the ordinance, the zoning ordinance. So this would then make it higher if they didn't build the healthcare center. If we pass this, can they now go to 150 feet even if they don't build the healthcare center? You know what I'm saying?
The Alton Road Gateway District has a height limit south of Sixth Street
Uh-huh.
of 518 feet. North of Sixth Street, they cannot build 150 feet.
Okay, I got it.
Not build beyond 150.
Okay, thank you for that. I'm surprised staff.
Oh,
is-
wait, hold on. Then what did he
Okay.
just say they agreed to 100 feet on? He just said they agreed to 150.
That's the negotiation that's happening for the amendment of the property on where the health community health
Is
center
that
is.
south of Sixth?
That's north of Sixth.
Right. So to Gail's point, right now, what is the restriction there?
I believe.
It's 65
believe
feet
it's
if it's an
65.
office.
Oh, and they're trying to go to 150?
Yeah, so
Yeah.
I am right. So if we pass this, they will be able to go to 150 because,
No, there's a note, paren one, probably should have included that in the draft, is south of Sixth Street. Let me go to it real quick.
You're talking about the footnote on page,
Footnote.
so it's on page 52 of the book.
But the footnote is not in the garage.
Oh, okay.
See, this is confusing. This
on, no.
ordinance says.
Yeah, they're looking, I think you may be right. They're looking, where's the footnote? I don't see it.
Do you see where the 519 is stricken and it says 150 and then there's a paren
What
one?
page are you on the
Oh,
book?
I'm
On
sorry,
page
page
52, right
52
here.
of your
Oh,
paper
okay,
book.
got it. Yeah, yep.
There's a notation on the right that the number one in parentheses, that's a footnote.
Oh, wait, no. that's
Where's the
not-
footnote though?
I thought it used to say south of 6th. So
I think they didn't,
I think it got cut off.
Nick, where's the footnote?
not in-
Well, that's what
It
Rogelio
looks like it got
read to
cut
you.
off.
Oh, because that's important.
Minor detail.
And we can include that for.
No.
All right, so is your point that footnote will say something to alleviate Gail's concern?
No, it doesn't. So it's the way I thought it said south of 6th Street, I think that was removed, not removed, but just not part of the code.
So the board should
Yeah,
include.
That's definitely
so the board
important
should
because
include
right
that.
now, there's the empty surface parking lot on the northeast corner of 7th Street, which my understanding, because of the downzoning, is under FAR. And if we're essentially decreasing the height limitation
That
for
only applies to
500
6th Street.
Alton, but upzoning the rest of the area, that would then make that a possible development.
The way it's worded now, I would say the height limit for the whole Alton Road Gateway District is 519 feet for main use residential.
Oh, including 7th Street?
Mhm.
Okay, so this would limit it. All right. Just want to make sure we weren't doubling it. Okay. All right, Gail.
Are you, so as I read this ordinance, at first you think, oh, you're decreasing it from 200 feet to 150 feet. But actually, aren't we increasing everything that is currently maximum 60 feet to
No.
150?
No, because this is only in the Alton Road Gateway District, which has a defined boundary of 8th Street on
You
the
said
north.
everything south of 23rd Street is now allowed to be 150 feet. Is
In
that
the
what you said?
RM3 district.
Okay,
So at the end of the ordinance, there's a map, so you can see the areas that are affected by this ordinance. The RM3 district south of 23rd Street, which there's a map on page 46, is in orange. That area is where currently the height limit is 200 feet. This ordinance, if adopted, would reduce that to 150 feet. On the lower left, you see the Alton Road Gateway District. The Alton Road Gateway District is from 8th Street is from 6th Street on the south to 8th Street on the north.
Uh-huh.
If adopted, this would reduce the height limit for main use residential from 519 feet to 150 feet.
Wait, yeah, hold on.
something
You know
doesn't,
where the surface parking lot is on the northeast corner of 7th Street, right?
Mhm.
Behind Federation Tower?
Yep.
You couldn't go in and build 519 feet there if it was residential.
I don't believe so. There's not enough FAR for that.
well, if they
Uh,
move the FAR, they could. See, we were scammed on the whole ballot referendum, folks. Everybody out there who voted for it, you voted for 519 feet. Please continue. What else is reduced?
So in terms of heights, those are the only areas that are reduced. Everything else south of 23rd Street is below 150 feet.
Okay, thank you.
So
very
150
much.
feet would be the highest height limit allowed south of 23rd Street. Then the other things that it does is for the CD2 district on Washington Avenue, which has a height limit of 75 feet, and the MXC district, which has a height limit on non-oceanfront properties of 50 feet, would provide setbacks for any portion of a building located above 75 feet on Washington Avenue or 50 feet on Ocean Drive or Collins.
No, I think what you guys did with setback is genius, unless the state preempts us. But you did a lot of work on it, and I think you did a really great job. But I'm going to go with the three commissioners who are sponsoring this ordinance. I think it's correct that we should reduce those certain zones to 150 feet.
And I think just to Gail's point, if the board transmits this with a favorable recommendation, we'll clarify that the 150, that only applies south of 6th Street. Anything north of 6th Street in the Alton Gateway is subject to the underlying
Right.
height restriction,
good,
which is it 65?
That's what I think it was.
For office
should be.
development, it used to be 50, and then it got to 55, and now it's 65 if it's an office.
Okay.
Why
think
are
the,
we not incentivizing residential housing instead of office.
Another discussion and
Can we include that in this?
Alton Road, a decision was made a few years ago to incentivize Class A office development, and they were given an extra 10 feet or 15 feet in order to be able to incentivize the development of Class A office space as a way to transform the economy of the city.
So now we have a whole bunch of those projects coming on. So this is another opportunity to, as we, again, legislate for what we want and need instead of what we're reacting to, can we not swap out that incentive?
I think that would be unrelated to this. I think that should be a separate ordinance referral if we want to look at what we're trying to incentivize on Alton Road. I don't think that affects this in any way, shape, or form because that height limit is 75 feet. So I don't
Okay.
think it's relevant to this particular issue. But certainly that's, you know, if you want to make a recommendation that the city looks at the office incentives and modifies those to be residential incentives, that's certainly something that we could look at, but I don't think it has any impact on this particular ordinance because we're not talking about a height limit that's beyond what's currently allowed.
So when we're done with this one, can you just also transmit that we recommend, yeah, we're opening up for discussion
Mhm.
on that? Okay, so Brian's not here for right now. So Gail, do you have any other questions?
just going to say that I'm all for this.
Okay, Joe?
Favorable.
Jonathan?
Seems it. Favorable.
Okay, you feel?
Favorable, and I'm just to specify, I'm in favor of doing whatever we can to that last point, to change incentives, to try and, you know, push for additional residential development. So I think that's sorely needed in the city.
Okay.
Doesn't something like this, though, what we got coming in here, the kind of balance out whatever the incentive of the office space there would be? I mean, doesn't that kind of balance it out where there's,
What do you mean?
well, we're gonna be attracting anyway some more development for housing. So I just think that if you just make it easier for development and less office space in that area, which you're because we're looking for more affordable housing and
Right.
not necessarily, so doesn't this kind of counteract against the office use?
Right, but I'm saying in addition, like we should take a look at overall what we're incentivizing. As separate from this.
Right. Okay, so you're not talking about this specific area in general, you're just talking about general in the city.
Well, I raised it as specific to this, but based on Rogelio's comment, I'm like, let's back up and just look at it. You know, encourage the commission to take a look at, maybe it's time to reimagine that incentivization. Like, for instance, the MXC was designated MXC decades ago to
Right.
incentivize hotel
Right.
use, right?
Right.
But now it has outlived its designation, so why are we still holding on to the MXC designation, right? Incentivization worked. And so now we should be looking at using incentivization to stimulate other types of development or business uses or whatever that we need now, not 40 years ago.
Correct, but I'm just saying, we've got to be careful too, if we're targeting an area like this, what you're going to be attracting is more high-end kind of living spaces. What we're
Understood.
looking for is more work,
Correct.
more affordable
Right, which is
housing.
why I'm saying,
So I
let's
just,
pull
I
it
just,
back
yeah,
out.
yeah, so,
Yeah.
so let's be careful not to target that.
No, no,
specific
that's
area,
why I
'cause
was
we know
saying
who will
let's-
attract in that area.
Yes.
All right.
So I actually do have a comment. I'm sorry, shocking, I know, but I love this. I think it's with the height caveat. Why can we not, so pass this, but also encourage the commission to do this same exercise for the rest of the city? This is not the only part of the city where we have historic preservation needs. We have beautiful mid-century modern buildings all up and down from North Beach, and we've got other types of buildings that need to be looked at. So I not to take anything away from this, but now let's go and do this for the rest of the city and post haste.
I would just add, the North Beach districts are RM1, so they're not affected by the Live Local Act. So there's no danger for those as far as the Live Local Act goes right now.
So
but
what's
just-
good, so you're telling me that the Live Local Act will not have any impact on the empty Deauville site?
I believe that's RM3. No,
No, it won't have any
it
impact.
will not.
Town center.
Town
is,
center, it might, but town center already has the highest height limits in those areas, so really doesn't affect the town center too much. The one area it could affect is Normandy.
Okay, so
Normandy Isle.
So what I'm seeing in Normandy right now is an aggressive outreach to buy up those multifamily, naturally occurring affordable homes.
Mhm.
And so even if we don't think there is going to be a need for something, I would like to encourage the commission to direct staff to do a comprehensive review for the rest of the city to make sure that we are leaving no stone unturned in protecting what makes this city special for all of
We're
us.
not reactive again.
Yes, because if we don't think it's going to be necessary, I guarantee you somebody out there says, oh, I just got an idea. And I want to get to that idea before they come to us saying, we found a thing that we can drive a truck through. Thank you.
And Tanya, I would just ask on that, if you could make that again as a motion after the
totally
board
separate.
transmits this
Yeah,
one.
yeah.
Okay.
But Rogelio, you wrote it down because I won't remember what I said.
Comprehensive review of development regulations to ensure that naturally occurring workforce housing.
And other, like, I don't want to limit it to just that. Like, let's just see what's out there that may fall victim to this. And then decide what we want to do about it as a city.
Okay, just to be, just for what I said, for Normandy, I meant the commercial district only of Normandy. So the multifamily residential areas
But
would not
remember
be
the
subject to this, but yes.
But remember, the commercial
Mhm.
part of Normandy has store, like New York, has stores on the bottom, then
Right,
two
a few-
stories
yeah,
of
a few apartments
residential
on top,
upstory,
yep.
which works great in New York, and maybe we want to increase that to 4 stories, and maybe we don't. I don't know what the answer is. But let's not just assume that because there's a flower store on the corner, that the next building doesn't have 2 stories of apartments above it.
Mhm.
So again, it's just, there's no single answer for every part of the city, but I want us to know, make informed decisions.
Mhm.
So that-
Abbott Florist. Love Abbott Florist.
Abbott Florist, yep. Yep. Okay, so that was my comment.
so just to summarize, you guys came up with this ordinance to combat possible out of control height that might be imposed by the Live Local Act. And you concentrated on South Beach for this. And in North Beach, you didn't look at it because already the maximum height is 200. Is that what it, now, did I get that right?
I believe the referral was intended to focus on South Beach, so that's why we looked at South Beach.
So you didn't even look at North Beach because you advised the commissioners on how to write this ordinance, and the commissioners told you to just look at South Beach? Is that how it went down?
I think the immediate concern when this was referred, and remember, all of this happened very quickly.
Right.
The immediate concern was to look at heights in South Beach, particularly in the Art Deco district. It's not to say that, and
Right.
it sounds like the board is going to adopt a separate recommendation to look at other districts in the city. It's not to say you can't.
Yeah, I'm
But
glad you
this
brought it.
item is limited to South Beach.
Yeah, Tanya, you're right. It wasn't even considered and
No, and I
it should be
understand.
looked at. That's,
Yeah, no, and I understand that because, Ocean Drive, Art Deco, that is our postcard. That's what drives our economy. I get that. And I'm not denigrating that immediate, like, oh, under siege, let's fix it notion. So now we're addressing it. Now let's expand that exercise to the rest of the city and see where there are pockets.
You're saying
that-
that would be in a separate motion
Yes.
recommendation. All right,
Yeah.
I was in the restroom, so I don't want to interrupt anybody, but did we discuss the possibility of a way around of the non-conforming use issue with grandfathering?
We can make a recommendation as to that. The title doesn't include the non-conformance section of the code, so I don't know if we can touch that as part of this or if that would.
And the
need to be
reason
separate.
it's obviously a big issue because
Yeah.
you don't want a non-conforming building not to be able to make renovations.
Right.
But can it be going forward instead of retroactive?
If the board would like us to explore that,
Yeah.
I would say include it in your
Recommendation,
recommendation,
okay.
but with the only caveat is I want to make sure that if we're allowing the existing non-conforming heights, if we're going to treat those as conforming, then is that
Is that essentially the height limit?
does it undermine the the purpose of the.
So
of
wait,
the-
you're
So we,
saying-
I'd like to look at that. If
Okay.
we can do it, we'll do
Okay,
it.
great, that's all.
Okay.
Obviously, this is all within the confines of
Yeah.
law, what you can
Just
do.
to make sure somebody doesn't say, well,
Yeah,
even that's a legally conforming height, therefore I should be entitled
right,
to that.
correct. I get it.
Wait, I'm sorry, say that again?
That well,
If we treat the height of existing projects as conforming, then are we in essence keeping the current taller height
Right,
limitation?
but then that flies in the face of your other concern, is if you deem them non-conforming, then they can't. So now I'm confused.
Yeah, I'm
Well,
very.
you're right,
confused.
you're right.
Yeah.
You're right.
Catch 22.
You're right.
Okay.
But what I would
So it
say to
is a
you is
catch-22.
we'll look at whether,
Okay,
we'll look at whether there's a way.
right. So that they're
to-
not deemed conforming, but yet they're not impacted by their inability
Yeah,
to,
either-
okay,
right.
yeah, I
And-
get it.
and So and this goes back to the issue of, we're trying to disincentivize people from building something new that's
Correct. They understand. the goal.
super, super high. No, I'm just making sure I understand.
Yeah.
But if you're an existing and you're trying to renovate, then.
Right,
that's
he's
the-
saying if we grandfather them to where they're conforming, that may
But isn't the
eliminate.
term of a legal definition difference, term of art, whatever you want to call it, between or is there between grandfather and legal not conforming, non-conforming?
Grandfather is basically shorthand for legal.
Okay, that's what I
non-conforming.
thought. So.
Yeah,
Mhm.
yeah.
I mean, because I think what the goal is that we want to protect those who are good actors who want to renovate their properties, but
Right.
not put in 200-story towers,
New
Right.
ones, right,
new ones.
right,
And so that's what you're going to explore is figure out
Correct.
how we can do that without
That's right.
opening up the floodgates.
correct.
Right.
Okay,
Okay.
have fun with that.
Anyone else have any comments or you want to move it? No one ready to move it?
I'll move it.
Okay, Gail, I'm
Tanya.
sorry, Tanya, looking at Gail, talking to Tanya. Gail, you
So
want a
the,
second?
we're gonna have two motions though, one for
Well,
the,
we're gonna start with sending it with a favorable recommendation. That's
But-
what's on the table.
So I would like to send it with a favorable recommendation,
Oh,
But-
sorry, you're right.
but not accepting the unfavorable recommendation for portions in the ordinance related to height limits.
Right, you're transmitting all of it with a favorable recommendation
Correct.
with the fix about the heights in the Alton Gateway that I read into the record.
It would be three things, favorable setbacks, favorable height, 150, and favorable asterisks about the Alton
That's a
Gateway.
separate-
Right, so just so I understand Tanya's motion, so she's contrary to your recommendation to the unfavorable on height, she's making it favorable on that as well, but on a separate motion, we're gonna ask you to look into how to ameliorate that concern
Can we
about
just?
conforming
can we,
uses, right?
Mhm.
Okay, all right. Because that is a
wait a minute.
concern to me, so I have no problem supporting that motion as long as you all look into, or the commission looks into a way to remedy that concern.
To
about
limit,
not-
and it would be to limit the impact of these changes
Right,
on
on existing
existing
buildings.
development
Correct.
that would be rendered non-conforming.
Correct, correct. Is that something you're receptive to? Okay,
Yeah,
great.
I want to, hang on a second. I just want to make sure that this is strong enough, because I would rather pass it the way it is with the height limits pending your review on how to address it, as opposed to, I don't know. I don't know
No,
how
I'm
to
not doing
articulate-
that. Why
No,
are we
you're-
trying to fix a problem that doesn't even exist?
No, that's what I'm trying to get to, Gail.
No, your motion is to approve it, the whole thing. That's it, bottom
Yes.
line.
Right,
Great, then we're
Correct.
gonna make a recommendation that they see if they can remedy the concern for
That's what I
not,
want to make
fine.
sure.
Okay, so that's Tanya's motion. Does someone second it?
so the motion is to transmit the ordinance, including the height changes
Favorably.
with a favorable
Right,
recommendation.
that's the
The only
motion.
other thing I want to include in this motion is the fix that the board discussed about the Alton Gateway on the
Right.
north or
Oh,
south
that
of
would go in
6th
this
Street.
motion?
Yes,
Okay,
Because that's
yeah.
what's-
all right. okay,
Yes, I second that.
okay.
okay, roll call.
Okay, motion by Ms. Spot, second by Ms. Durham. Roll call, Ms. Speedy,
Yes.
Spot,
Yes.
Mr. Cement. Yes. Ms. Durham,
Yes,
Mr. Elias.
Yes.
Mr. Frieden.
Yes.
Mr. Magazine.
Yes.
Motion passes.
So then the next motion would be to ask you to investigate how to address the thing.
And
Yeah.
that, and what we're addressing would be the impacts of the height amendments that you just transmitted with a favorable recommendation on existing development.
Correct, how to minimize
How to minimize it.
the application that would be to their detriment to
Right.
existing buildings.
Because you don't want, you,
We don't want
We don't
non-conforming.
want to disincentivize adaptive reuse
Right.
and redevelopment in favor of demolition.
right.
That's what we're trying to get to.
Right.
Right?
Yeah, I have a simple legal, why can't you grandfather in existing buildings without that deeming them conforming,
Well, by operation of law, existing buildings
right?
are
Conform.
grandfathered. They're treated legal non-conforming when
Right.
when the code is amended.
Right,
So I think what Tanya's concern is if a property owner of a non-conforming building needs to.
no, I agree, that was your
By more than
concern,
50%,
right,
that the new building would have to comply with the new.
right,
code.
all I'm saying is why can't it be as simple as you're grandfathering in existing buildings? And that's it, and anything new has to comply, I'm not sure I understand why that's so difficult.
I think we understand what the board's
All right,
asking us to
okay.
look at.
Okay,
And then, okay, so we need to vote on that, right?
yep. So we have a motion
Yep.
by Tanya, do we have a second on that?
Second.
Okay,
Motion second. Okay, roll call, Ms. Beatty,
Yes.
Ms. Bott,
Yes.
Mr. Cement,
Yes.
Ms. Durham,
No.
Mr. Elias,
yes,
Mr. Frieden,
Yes.
Mr. Magazine,
Yes.
motion passes.
okay,
And then the third motion is to encourage the city and staff to do the same exercise for the entire rest of the city to identify pockets of opportunity for improved protections. Or something better worded than that.
okay, do I have a second?
I second.
Okay, we have a motion by Ms. Bott, second by Ms. Durham. Roll call, Ms. Beatty,
Yes.
Ms. Bott,
Yes.
Mr. Cement,
Yes.
Ms. Durham,
Yes.
Mr. Elias.
Yes,
Mr. Frieden.
Yes.
Mr. Magazine,
Yes.
motion passes.
great, we're gonna take a 5-minute restroom break.
And
Yeah.
there's lunch also in the
Oh,
next room.
great, okay. Then we'll take a 10-minute break, and then we'll go on to our discussion items.
I didn't think we were going to get to lunch.
Thank you for joining. We're about to start the meeting. Please silence all electronic devices during this meeting. Please stand by. We're going on air in 5, 4, 3, 2.
Okay, sorry, that was a little longer than 10 minutes for any of the millions of people watching on television. We are going to go on to our discussion items. The first is uses in residential marinas.
Okay, so this is a continuation. The planning board was discussing this item a few months back, and it's been deferred. It was as a result of a request from the planning board. They wanted to discuss how we could better regulate uses in marinas. Apparently, there are concerns that rentals and other types of commercial activity, water-related commercial activity is taking place in what should be a residential marina. We don't have a lot of regulations regarding what happens in marinas. So I included in the staff report the regulations that we do have related to marinas. They're primarily related to public docking spaces. And so the lack of the ability to dock in public seawalls, prohibitions on projecting structures into waterways. And then we do have two districts in the zoning code, the WD1 district, sorry, only one district, the WD1 district, which does limit what happens on the marinas in that property. The WD1 district is the little strip of land along Collins Avenue, generally north of 41st Street. There's a tiny little sliver of land along the Indian Creek waterway that is intended to provide some accessory uses for the hotels on the east side of Collins Avenue. And so it regulates what can happen there, but it does provide the ability for, there are regulations, so it provides for the ability to rent watercraft, excluding jet skis. It does allow for wet dockage of pleasure craft, waterways and decks, and water transportation stops in that district. The rest of our zoning districts are basically silent on how marinas are regulated. So with that, I leave it up to the board to discuss.
Yeah. Yeah, so, I know current commissioners are working on the public marina issues, and they're different from each other. The Sunset Harbor marina issues are complicated and different from the Montes Marina, which are different and complicated. And that's not this. I mean, that is a part of the conversation in general, but this is more about the notion of, I live in a building, hypothetically, somebody lives in a building where there is a marina, and somebody on the buildings board has said, hey, listen, we have an opportunity to monetize our marina, and we can accept charters here if the board allows it. And the board says, sure. And that's great, but is the board also regulating what happens? Now, Brian, I think in your buildings, that is happening, but in other buildings, it's not. And so you have a boat charter company or jet ski company where they rent the boats for a day-long charter, and then at 9 o'clock they come off the boat. They have a day's worth of trash. They're drunk. They're hungry. They have to pee. They may be horny. And where are they taking care of all that stuff? I mean, that's just how it is. I mean, right? And so we've had horror stories of people like going out to walk their dog and finding people in the bushes, doing whatever they do in the bushes, or trying to find a bathroom, or traipsing through the lobby to get from the marina to the street to get picked up from an Uber. So that's all. And where does the trash go? Does it just get dumped on the marina? Does it get dumped into the lobby trash cans, which are not receptacles that are appropriate for that? The noise, all these issues not contemplated, and most buildings are not well enough organized to think about this comprehensively. So
Just out of curiosity, so if you had a case like that of a building who agrees to do that, wouldn't they have the power to also reverse that and just cancel the service or the charter service to be using their dock if they saw it was problematic?
They would, but maybe they don't necessarily want to lose the revenue, but they haven't thought prospectively about how to manage that. So if you're having a BTR, if you're granting a license to somebody to operate a business, it's an unintended consequence of, sure, they have a business license, they're conducting their business in our home, end of discussion. So what can we do? And I'm not saying necessarily that it needs to be regulated, but maybe there is a framework that can be circulated. I'm not sure what the right process is, but nobody's talking about this. And so, you know, this is something that came up in the beginning of the year that I talked to the folks on the Waterfront Sustainability Committee, whose name I will never get right. I will never get the name of that committee right. And I've talked to buildings at Wavna and in North Beach, and it can be as small as a fourplex or, a 12-plex little condo association tucked away someplace where the management company is trying to monetize the dockage, but the residents who are renters don't have any way to prevent people from coming through their living space with unintended consequences. So again, I'm not trying to put anybody out of business, but as the city evolves, there was never an imagined use where you would have to regulate business of charter boats or jet skis in a private building at this scale 40 years ago or 60 years ago when this language was written. And so I think it would behoove us as a city to put some thoughts together and recommend the commission take it up to try to put together a code of conduct or parameters that need to be met the way we do for any other business operation that happens, right? So, we have short-term rentals that happen in somebody's home, where in some neighborhoods that's permitted, in some neighborhoods it's not. If you wanted to open up, a tailor shop in your apartment, are you allowed to do that or are you not? Or if you want to open up a medical practice in your front room, in your single-family home neighborhood, are you permitted to do that or not? And if you are, that's fine, but what are the rules of engagement? That's just what I'm trying to get at, because that doesn't exist, and it seems like it's one of a few things that needs to be addressed.
And also, Tanya, I agree with that, and I'm glad you brought this up, and you brought up some points I didn't even think of. And I also wanted to look at this, how I thought of it as the future mooring field. The rules, maybe we could add some rules that kind of will affect that. It could be up to 600 boats they're going to be mooring out in the Biscayne Bay. And second of all, Joe mentioned this to me before. The Bentley Bay is on West Ave. It's a condominium, but there's a private commercial dock next to it. And the people who live in that condo building, that condo association, have no control whatsoever over that commercial marina that is attached to their building. So that's why I think also it's important to keep in mind rules.
Yeah.
Yeah, as well, in other areas along West Avenue, I think while there could be private ownership of the condominiums, maybe the original developer of the buildings actually retained some of the common areas or marinas. I'm actually surprised that we don't have more outreach here, because the unintended effects or impacts on residential neighborhoods from some of our marina districts has just absolutely expanded and compounded over the past, let's call it year, 2 years, or most notably post-COVID. I would really love to go about this in a very thoughtful manner with more input. Begrudgingly, we don't have much of an audience here.
Yeah, but could we, the first sentence in the letter that we got from the Marine Committee says, we would appreciate the opportunity to engage the entire Marine Committee with the Planning Board on the issue at some future date.
Well, I was going to
We-
suggest we
Yeah,
have.
we did that with the affordable housing. They
Yeah,
came and
let's-
gave a presentation.
Because I think it goes beyond too, that everything that has to do with water usage in our city has sort of went out of control, and everyone's, we've had the same thing, Monument Island, where we're, trying to restrict the usage in Mooringfield. So there's a whole sort of planning that the city has to do on how we continue to encourage water use, but it makes sense for the residents and for the environment.
So does it make sense to then, I don't know what the mechanism is, but move this to the next meeting and reach out to the particular, whether it's WAVNA or Buildings in North Beach and the Waterfront Sustainability Committee and say, this
Yeah,
is gonna
Gail,
be-
I would love it if you'd find out from them. Is December a busy agenda?
We have, I think, two or three ordinances and 4 or 5 private. So, yeah, it'll be much busier than this one.
How about January?
Don't know yet.
You wouldn't know yet.
Yeah,
But maybe, all right,
yeah.
maybe we move it to January. That gives them a few months to see if they're available to come.
Then they can have 2 more meetings at their committee. And we should, that would be great if
All right. Is it Amy?
Yeah, she's not the president, Ben is. And I'll reach out to Amy and Ben and see if they could get
Yeah,
together.
what, do you know the date currently of the January meeting? 20? Just so Gail can let them know in advance.
And Gail, let Amy know for WAVNA and any other buildings. And I don't know how we find out about other.
Well, Amy and Tim
It's,
are on the board of
January-
WAVNA and on the Marine Committee.
No, I know,
Yeah.
that's what I'm saying, so that they
Yeah.
let WAVNA buildings know, not just the
Oh,
board.
yeah, that's a good idea.
Gail, the meeting is in January 30th,
January
2024.
30th? Sorry?
January 30th.
Oh, okay. Yeah, so see if, so can we put on the agenda a
Yeah.
further discussion item on this? Sure. And then hopefully they'll be available.
And
If they're
Sarah
not
Gillis Reyes.
available, let us know and then we'll move
Yeah,
it
well,
to
out of the whole committee, there's, 7 or 9 people. I'm sure they can get
Okay.
3 or
That's,
4 to come in.
and that's the Waterfront Advisory Committee of the city, or that's of a?
It's
of
the
what?
city of Miami Beach, Marine, Water, and PA. I don't know what that stands
Oh,
for.
okay.
It's the city's committee.
Yeah, yeah, yeah.
Yeah,
Um,
the city committee.
I think, is it Parks Department that staffs that? I'll look into
And when
who
is it,
staff-
January?
30th.
What would the great, to put in a new ordinance?
We'll email you,
Or is there one existing?
the
There
calendar
isn't
of
one
meetings,
existing. Nothing, that's why.
probably tomorrow, so you have that for
Okay,
next year.
good,
Yeah.
good. Thank you.
Yeah, and the goal is to come up with recommendations that we could send up to the commission to create an ordinance that would provide a framework. If that's the right end
So there's, no
result.
what governs them now?
Nothing, a BTR.
Well, I think I think that any amendments to the land development regulations would be, like any other amendment to the LDRs, it would be prospective as to new residential
Right.
marinas. It doesn't mean you can't also make recommendations about operational issues. I think
Right.
this is a topic that we've been hearing from residents on.
Like right now, the way it goes is if a business gets a BTR from the city, which is a very, in this case, seems to be a pretty slim review process. I don't know what it's supposed to be. I have nothing to compare it to, but having sat in on a few of these meetings, like questions that I have just from listening don't even get asked. And so, and that's one thing. And then, what was the other thing? It's a BTR, and then the board of the building has to permit it. But again, boards of buildings don't always agree on things. And then if you're in a rental building, you're in a different seat. You're in a different situation. You don't necessarily have the same ability to manage what happens in your building because you're not an owner, you're just a renter. And if the owner of the building says, we want to do this, you're living there with the unintended consequences.
Okay. Anything else? I mean, we'll put it on that January agenda.
Rogelio, could you make sure that Amy's letter is in the packet in January?
Sure.
I think it's really
Yeah, and
important
also,
information.
and Brian had sent a couple of months ago his buildings.
I thought it was attached, we had it attached last month, and I realized that, that I
No, no worries.
inadvertently, my mistake.
And hopefully we'll be
it's all
sending this up to
Yeah.
Tanya and Joe. Okay, well, with that,
Wait,
oh, I'm sorry.
are we done with our
Oh.
new business?
No. Well, we're done with our discuss, oh, I'm sorry,
No,
you
there's
are
another
right,
discussion.
my bad. Okay, lot split unit size criteria,
So for this one, I'll show continued to,
January,
to January 30th by acclamation.
yeah.
Item name. Okay. The next discussion item was requested at the last meeting by the planning board, and it's related to the lot split criteria. Let me go to that page. Lot split unit size criteria. So for the purposes of the discussion, I included the criteria that we are required to apply pursuant to Section 2542 of the Resiliency Code related to lot splits. So in every staff report that you receive, you'll see this criteria identified, and staff goes through the criteria to make sure that the proposed lot split complies. In particular, related to unit size, related first to lot size, we look at criteria number 2. Criteria number 2 says that whether the building site that would be created would be equal to or larger than the majority of the existing building sites, or the most common existing lot size and of the same character as the surrounding area. So we do an analysis of the lot sizes in the vicinity to make sure that the proposed lot split is going to be compatible with those average lot sizes.
Why does it say,
Generally,
why does it say larger and not smaller than also? A
uh,
lot split is when you make something smaller.
right. So it's to make sure that the proposed lots are equal to the surrounding lots.
Right, once they're split.
It's not the size of the building, it's the size of the lot.
Yeah.
If the proposed lots are significantly smaller than the vicinity, then they would be out of character is the thought.
All right, well, I'm thinking of the one we just approved. It seemed a heck of a lot smaller than all the other lots. So I don't know, that criteria, just went out the window. And
But it wasn't, no.
I don't
I
think it
think
was.
it complied
We're
with
talking
the
about lot
average.
size, but
oh, the lot, okay, so I'm thinking of, okay, so do you take in, okay,
I'm
Yeah,
talking,
the
this
lot
is first
size.
is the lot size. Unit size is the next criteria.
So I don't remember who brought this up, so who's,
did.
so what was your goal in mind?
The idea was that we had one set of standards for a lot split, one set of standards for renovation, and one set of standards for new construction. And it seemed like it should be more consistent than it was. And that was the conversation we were having, that it didn't make sense that you got more or less if you did one thing or another.
Right.
So for unit size, we look at criteria number 3. Criteria number 3 says whether the scale of any proposed new construction is compatible with the as-built character of the surrounding area or creates adverse impacts on surrounding area, and if so, how the adverse impacts will be mitigated. To determine whether this criterion is satisfied, the applicant shall submit massing and scale studies reflecting structures and uses that would be permitted under the land development regulations as a result of the proposed lot split, even if the applicant presently has no specific plans for construction. So to analyze this criteria, we use the property appraiser's data on the unit size, which is the best available metric that we have. It's the only metric that we can really get to look at a large number of properties in the vicinity and average that, and take that average and get those statistics. We then apply a 20% allowance for reasonable accommodations for future renovations and additions, because we assume not every property is going to stay stagnant. They're going to be changed. So we assume that each property is going to increase in size by 20%. And then we get that average number of unit size, and we base our recommendations on that. So at the last meeting, we had 2 lot splits. In one of them, it showed that the average exceeded 50% unit size, and so our recommendation was that the home be allowed to go to 50% unit size. In the other application that came before you, the average showed to be, I believe, in the upper 30s. And so our recommendation was a little more moderated, that the unit size be limited to 40%, I believe was the number that we had. Could be off by a few percentages, but I believe that was our recommendation. So we look at what's there in order to provide you with a recommendation for the lot split. Now, it's true if they weren't splitting the lot, they would be able to do a much larger home, but that home would have larger setback requirements because setbacks are based on the width of the property. And so the impact of that larger home would be mitigated by the fact that you have a larger setback.
But if it were, if the lot size is the same at the end of a lot split versus purchasing a lot that doesn't have a property on it versus purchasing a lot that does have a property on it that either is going to be demolished or renovated, right? So the lot is the same size. What you can do in each of those circumstances with those properties, depending on whether it's a lot split or a vacant lot or property to be renovated or property to be demolished and rebuilt, those criteria are the ones that are different, right? For the structure that goes onto it.
If you're not requesting a lot split, you would be subject to whatever the regulation for unit size is in the land development regulation, which is right now 50%. If you are subject to a lot split, it would be by whatever number the planning board selects.
So why wouldn't it be consistent with, like, if you get a lot split and it's the same, maybe I'm not understanding it right. So if you have two pieces of property that are next to each other and they're the same size, one had come from a lot split and one just existed, they would be able to do two different structures?
Potentially, if the planning board, as part of the lot split process, approved a lower number, then yes.
So you're pushing for the lot splits to have the same rights as a lot that's already existed and vacant, is what you're asking for?
If it's the same, I just wanted to be consistent across the board. And if you're building from scratch, do you get some different number, or that's the underlying whatever you're allowed, you're allowed?
If the lot is currently empty and you don't need a lot split, then you can build build up to whatever.
Okay, so the only thing
code
that
allows.
determines a different size of structure is whether or not you build a lot split. If you build on a lot split.
On a lot that was split,
Yes.
yes. If the planning board determines that reducing that number is merited for reasons of the context of the neighborhood, yes.
And you're talking about the lot coverage, Tanya? Or,
Yeah,
that's what's different?
The unit
Yeah,
size.
the unit
Because
size.
what's happening is you
40 to
had one property there that had a house that was not fully, taking up a huge amount of this property, and then you suddenly put three massive houses in that one property. It has a real big impact on the neighborhood, especially if the rest of the neighborhood is not taking up 50% of land coverage. And so, I guess the purpose behind it is so that the neighborhood can incrementally grow, or the house sizes can incrementally grow during the natural course, but you don't want a developer coming in, splitting up all these lots and putting in 50% coverage things, but, yeah. I guess, one question I had was, so in the context of that last lot split, they were, and I see one of the criteria or one of the considerations is the adverse effects or impacts on the surrounding areas by the construction and the new development. And we discussed it, that was discussed, and they said, oh, well, we'll make sure to do them either like one at a time, or we'll use one of the properties for all the trucks, not to worry. But is there anything, are we able to, I guess, set that in stone in any way? Because when we get that promise from a developer and then then they're not following that procedure,
There's no accountability.
there's no recourse for the neighbor when they're not following what they promised to do.
That's not anything we've ever done, but that's certainly something we could explore, that they're only allowed to be under construction for one lot at a time, something to that effect, and we can include that as a condition.
But that's a little bit debatable. Like, if I had a
I'm
neighbor,
not-
I'd rather them do it all at once and do it, dragging
Right,
it
I'm
on,
not saying
so.
to necessarily do that, I'm saying.
And it's
so
cost
when-
effective.
When they come in here, that particular situation, it makes sense to do it all at once, and they promise us and they promise the neighbors, we'll do it all at once and get it over with. Alternatively, we promise we'll only do one at a time so that the trucks aren't everywhere, and we'll do it, consecutively. And they promise us that, but then the neighbors come in like a year later and say they're breaking their promise. What recourse is there against the construction company, the developer, whatever it may be? I guess the idea is you want them to be promising things to get the approval so that the neighbors are okay with it, but if they don't comply with that, the neighbors need some sort of recourse.
There's no sorry, but at the end of the day, for them to be promising is not realistic. And, most of the time, they're dealing with a lot of variables, and they're dealing with construction companies and permitting, and there's a lot of stuff involved. So it's not really fair for people to take it at face value when they promise. That might be their intention, to make sure they're not disruptive. But I think a lot of the rules that we have in place in making sure there's a parking plan and constructions that is respected are there to protect exactly that, versus us trying to add in a layer that is not necessarily applicable and not necessarily cost effective or makes sense, because we can't really hold up to it. I think that's where compliance comes in, where they need to be effective in making sure that these parking plans, which is the biggest issue a lot of time they have, is having all these construction trucks taking over the whole neighborhood, right?
Yeah, and listen, I mean, they're always gonna have to comply with code, right? But when in a different scenario, they may say, we promise we're gonna put, the other one was that we're gonna put tall hedges here. And there's no code that requires the tall hedges, but that was done to appease the neighbor, so the neighbor withdrew their objections, and a year later, they come in and they say, there's no hedges, I don't have any hedges anymore. Don't comply with that, the
Yeah.
neighbors need some sort of recourse.
There's no, like, sorry, but at the end of the day, for them to be
that
promising is not
replaying?
I
really.
hate hearing my voice.
Oh my gosh, this is all staged.
It's a time space.
You're not
Yeah,
us.
Yehiel didn't even realize that wasn't us just talking.
And also, we didn't actually land on the moon, I'm just saying.
And no, anyway, I guess
Yeah, so-
that's my only in this lot split discussion, because, I mean, you know, this is gonna come before the planning board again. I always like to have the neighbor, the angry neighbor and the developer work together. I think one of my first meetings, there was a neighbor who was worried about her tree, and I think it was the development on Fifth Street, on Fifth. The neighbor was worried about her tree, and the developer said, we'll hire an arborist. We promise we'll hire an arborist, and we'll get that, make sure we protect your tree. And she was happy. I just want to, in this process, whether there's any way to put it in writing, or I guess, I understand that these are the criteria we're looking at, whether to approve or deny, but is it maybe a case-by-case basis, or is there some way to enforce it?
Something like the hedge is like, because those are important parts, and getting the neighbors, but isn't that part of some recommendations we can do to the design review board for them to
You
sign
can,
off?
you can certainly recommend that there be certain hedges and certain plant material, and if that, if those hedges ever die and they're no longer there, that they still have a board order that needs to be there. And the neighbor can let code enforcement know, hey, these hedges, the applicant agreed that these should be there. And code enforcement can require them to put those hedges, and if they don't, we can bring them back to the planning board.
So can
as
there
part of-
be a planning board order associated with this lot split?
Oh, there is.
There is,
Yeah.
so when you're putting in there the coverage, the area, the coverage 50% or 40%, whatever it is, in that order, you can put these conditions? Okay.
Yeah, when the planning board said, for example, the last one, the planning board recommended that there be landscaping, something along the property line, and that's in the order.
Okay,
Yeah.
cool.
So I guess what I was trying to get at was more about making sure that things were consistent, but it seems like there's not a way to do that without limiting our ability to do the best possible thing for the neighborhood.
It all depends on the neighbor. It's
Right.
neighborhood variable,
Right.
right? Like some neighborhoods all the houses are 50%
Right.
in coverage, and then another neighborhood, it's 30% coverage.
Right. So I get
And
that.
So then like you're doing the same exact lot split, but you're giving them less coverage because you want it to match the neighborhood. So it seems unfair that you're giving one person a 50% and one person 30, but
No, I'm not comparing it from neighborhood to neighborhood. I'm comparing it to different types of lots within the same neighborhood. But we'll let that go for now. The other part was, to your point, Jonathan, and Melissa, about making sure that when developers, whether somebody's building a house or renovating a house, that there is a traffic mitigation plan that ensures that trucks are not blocking the road and not, doing things that they shouldn't be doing the way we have now. And I don't know, you say there's a traffic plan, but I'm not talking about the traffic plan once it's built. I'm talking about the during construction traffic plan.
Yeah, they have to have a maintenance of traffic plan and a parking plan for construction workers as
And
part of.
does anybody enforce? Does anyone
Yeah.
check what's?
Yeah, you can call, because I deal with it in the Venetians all the time, so when they're not and they're taking over the street, you call the first time is a warning, second
Okay.
time it goes up to 5 times, and the fees are quite high, like they substantially, and then I think the 4th or 5th time they lose their permit, so.
Okay.
So you gotta call in, I'm not sure the compliance goes around checking, but if you call in, they'll show up.
Okay.
Yeah.
Yeah,
All right.
it's applied to construction above a certain value. I want to say it's $250,000, which is,
Yeah.
every new house is going to cost more than that.
For sure.
And they have to have a maintenance of traffic.
Okay.
Plan.
Oh, Rogelio, I misunderstood. So number 2, the criteria, I thought building site size also included the lot width. So should we add in the criteria that the lot width should be conforming to the other lot widths in the neighborhood?
Lot width would count as lot size. We don't have a good way to extrapolate that number without getting good surveys. So we typically just look at the unit size, and that generally, at the lot size, and generally a lot that's of a similar size is gonna have the same width, because for the most part, every lot has the same depth. So by using the lot size, you're gonna end up with the same lot width for the most part.
Well, when you split the lots, they all have the same depth.
Right, so when you
But the
split it, if.
Width is what's going to change, and that
Right.
doesn't seem to be, to me, that's the most important criteria.
Agreed, but when you split the lot, since the depth is gonna be the same, if you have the same lot size, by definition, the width is gonna be pretty much the same as the rest of them. So if they all have an 8,000, if every lot is 8,000 square feet and every single lot has the same depth of 100 feet, then you know that every lot is gonna have an 80-foot width.
Let me ask you, are most lot splits that you see a result of two lots that were unified and they want to split them back to the original plat?
For the most part, yeah. On occasion, we have seen a few where they had 3 lots and they want to split it into 2, and they have to get it after the planning board approves the lot split.
Right.
They have to go to the county and get it replatted into 2 lots.
Do we allow combination of lots anymore? I never
We
see
do.
that.
You can
Yeah.
get, you can
they
aggregate
rarely come-
lots, but there is a limit on the number of lots in single-family districts. I think you can, there's a limit of 3 lots in single-family districts.
Got it.
Yeah, we see it in North Beach with some of those smaller lots, and if there are multiple family units, it was a big deal like 6 or 7 years ago, and they were,
But do they require planning board approval?
I don't remember
In,
which board they come in front of.
in North
but-
Beach, in North Beach, there's a conservation district overlay that limits your aggregation.
Right.
I think
I
it's
believe to
3.
2 lots, and then 3 if you're doing workforce or affordable
But if they
housing.
want to get it, do they have to get approval from someone?
The building needs to be approved by either the Historic Preservation District or the Design Review Board, depending on where it's located. But you could technically unify the lots without the approval of the board. But if you want to construct one building that spans those 3 lots, then that would have to be approved by the DRB.
Okay.
Lots of unintended consequences.
Right.
I just wanted to ask, like, in general, I mean, is it a good idea, planning our city, to encourage lot splits, to build more housing? Or is it to keep the value of the neighborhood and maybe not have lot splits? Because I think lot splits,
Well, it's interesting, Gail, because what happens with lot splits is normally you'll get the neighbors come in here and they'll either support it or they'll, I guess it's a case-by-case basis. 'Cause I know your point, but I think it could be different from one situation to another. But the neighbors are always noticed, right?
Yeah, it's like any other project
Right.
that would come before the board, it's noticed. I would
And
say this is a
if-
fairly unique procedure for Miami Beach. I don't think a lot of cities have a planning board approval of the lot split. They do sometimes have planning board approval if a replat is necessary.
Right.
But if the lots are already legally platted as 2, for the most part, most cities allow them to build if they conform to the unit size and lot size
And
requirements.
depending on the situation, a lot split might get the homes or the lots back to the way they originally were.
That's what I asked, right?
Correct.
But let me ask you, so is there anything that you all as planners think we're missing or you should supplement? the
I
ordinance
think,
with?
I think it's a fairly good process. We have no shortage of them. We get them regularly, so I don't think it puts people off. I think people are still coming in to do the lot splits in many situations, so I think it works well. We end up negotiating some things to make sure that whatever's built is compatible, versus in other cities where they don't have this process. They just look at, do you comply with the regulations? And if you do, that's it, you can build.
Right, because I found what was interesting about the last split, the threat is always, well, if you don't give it, we're gonna build one big monster house.
Right.
Which they don't wanna do.
Right.
But I guess the reality is they could,
could.
and so, instead of
Yeah.
having a hotel there, you'd rather have 3 nice,
Very nice,
okay,
yeah.
all right. Any
Yeah.
other,
So, personally, they're my favorite analyses to do because they're very technical. I pull the numbers and I do the math, and our recommendation is based on actual
Yeah,
math.
math,
It's
yeah.
not, there's no.
it's all about being in scale.
Yeah, there's
Right.
there's no real judgment calls. It's the math. Does the
Right.
math add up? And so I love doing these analyses because I get to put my math hat on and use that I don't get to use too often. So so, anyway.
Any other comments? All right,
Happy
with
birthday to
that,
Nick.
I have one other thing to
Oh.
say, but not about
You
this.
get to sing happy birthday to Nick?
hold on, before we do that, Tanya has another comment.
Not related to this, and I just, on November 8th, I'm either gonna wake up as the vice chair of the planning board or as our next commissioner. And either way, it's gonna be good, because if it's the former, I get to spend the next 3 years with you guys, and that would be amazing. And if it's not, yeah, that's even better. But I will say that in case I don't come back to the planning board for the December meeting, working with you all has been an incredible, incredible privilege and honor. And I love how thoughtful this body is, and how
Congenial.
and collegial, but really working hard to get to the best solution. And that is too rare in the world, and certainly in our city. And I thank you for it. And
Well, if we don't see you again, thank you for your service, because
And-
you've been great.
Thank you,
thank
for
you,
letting
and
me-
thank you.
thank you for letting me drone on all the time, because I'm not always concise.
Joe, the same
Joe,
for
is there
you.
anything you have to say, Joe? Are you gonna miss us, Joe?
I love you, man.
Group hugs.
No, I'll say when it's applicable.
All right, that being said, happy birthday to you. Happy birthday to you. Happy birthday, dear Nick. Happy birthday to you.
Hold on, I think there's people on Zoom who wanted to join in.
Thank you all, I appreciate it.
All right, guys.
All right, so next meeting is, the November meeting will be canceled, and that item that's on that agenda will be moved to the December meeting, and that is December 19th. So,
Thank you.
Thanks,
Adjourned, thank you.
Thank you.
Thank you.